Well, hello, everybody. Wow. It's like we've been waiting for this moment for the reply to the sanction motion. We have it. It's here. And we're going to go through it. There is 5 documents, something like 124 pages or something like that. So if you need to go grab a tea or coffee or some other drinks, you go and do that. So let's get ready. So we've had Saltzy response to the motion for sanctions. There is sassiness. There is some shade. There's lots of footnotes. And there's just lots and lots of information. So hello. I know that EKC, she's gone through the documents. I'm going through the documents now. I know Emily's got one scheduled for the morning. So probably for the next 24 hours, there'll be lots of commentary on this. And so let's have a look. Just say hello to a few people. Yes, so my internet got fixed this morning. It was actually an issue with the connection on the street. So they had to fix that, and most of my street was out. So Aussie girls, they should be doing the round of creators. Well, everybody will have a different opinion and a different thought, particularly the lawyers. They all have different legal opinions of how things should happen. Just been having some discussions about it with a few people now, and everyone's got different opinions. Some people like the sass, some people don't like the sass. Some people like the shade, which I know it's the same thing. You know, some people like tables, some people don't like tables, some people like footnotes. So everybody has everybody has a different take on it. We can't get enough of the documents. Seems like this is going to be funny. Yes. And if you like footnotes, there is Kristen. I think she's actually going to be watching all the stuff that's happening, because I was I was watching her Insta live today, and I saw she had this shirt on, and I went, I swear I wore a shirt like that a few days ago. And that's why I did the who wore it better, because I thought, I'm sure I've worn that. So the shadiness needs to be renamed an eclipse. Oh, it's very shady. All right, thank you, Frank. All right, so I've got my triple shot iced coffee. I don't drink iced coffee very often, but I'm gonna need it for this, I tell you. And I've got water. So all right. So I wanted to show you KJ's live on Insta today, because it was I actually, for the first time ever, wanted to throw things at my screen. I wanted to throw things. I was so angry. But we are now going to look at these documents. So I know that some people have seen them, and some of you haven't. So if you have seen them, just remember some people haven't. So, and where there's some spoilers, if you can just be nice and give everybody a chance. I'm going to give you full screen, and I'm going to enlarge it. I don't know if Gail needs to get the corners ready today or not. And I won't even say about picking a word or anything. Peter's got her wine hooked up to IV, because this is document. So we're up to 65, document 65. Plaintiff's opposition to defendant's motion for sanctions, oral argument requested. Introduction. Only seen some so far, only what I could in the last hour. No way would I spoil it, Joe. No, that's all right. That's fine, Gail. It's just, yeah, there is just so much. I mean, yeah, all right. Defendant's motion to dismiss. Defendant's motion to dismiss is pending, yet defendants are driving up litigation costs by accusing plaintiff's counsel of misconduct, failing to observe the local rules. So we've got our first lot of shade already, and our first footnote. See defendant's motion to shorten time, docket 61. And filing needless and duplicative motions irrelevant to the motion to dismiss. Brown, I think Brown needs to go into the corner. Since filing the motion to dismiss, the defendants have filed 5 additional motions. Footnote number 2. This is the third of 5 motions defendants have filed since their motion to dismiss on December 2nd, 2020, which directly contradicts defendants' position that this court has no jurisdiction over this matter. And he's listed all the dockets. 3 of which require a written response from the plaintiffs. Defendant's motion for status conference, defendant's motions for sanctions, defendant's motion to qualify counsel to continue representation. One of which was struck by the court as improper under the local court rules. See this court's minute order striking defendant's motion to shorten time, docket 62. All 5 of these motions were filed within a 30-day period from January 18, 2021 to February 18, 2021. And we've got here, see dockets 39, 51, 59, 61, 63. Moreover, rather than filing a single motion for sanctions, defendants filed the instant motion and served plaintiffs with a second duplicative motions for sanctions under Rule 11, which presumably will be filed after the 21-day safe harbor period expires. All right. So that's the opening paragraph, people. So let's just say, hello, Rick. We've started straight away. I'm just going to go through some of these comments. So Rick's going to go straight to the corner by the looks of it. Hello, Nana Kimber. Dutch Spirit, Phyllis. I'm sorry if I forget you. Don't see you. I love professional sassiness, says Frank. Like and subscribe to this. Yes, it does. Yes, please make sure you're on live chat. Yes. All right. So we're up to the second paragraph now. In the pending motion, defendants seek to distract the court with accusations of improper conduct and declarations filed for improper purpose because the proffered testimony, 1, shows that defendant Katie Joy Paulson misrepresented the nature and the scope of defendant's Washington contacts. We're up to footnote 6, people. 6. See declaration Catherine Paulson in support of defendant's motion to dismiss, docket 19.4. So scope of Washington contacts in her declarations filed in support of the motion to dismiss. And 2, establishes defendants have sufficient minimum contacts with Washington for this court to exercise personal jurisdiction over them. Number 7, see declaration of Kim Fulmer, declaration of Michael Saltz in support of motion to dismiss, declaration of Lorianne. Moreover, defendants' motions for sanctions contain numerous misrepresentations, which is not the first time defendants have misrepresented or misconstrued facts to the court. Number 8, compare declaration of of Jeffrey Belenko at X123 with docket 46 at 14. For example, at the February 2, 2021 status conference concerning the Natalie Kennett declaration, Mr. Brown represented to the court he was reading from Ms. Kennett's declaration verbatim. Yet the language of Ms. Kennett's declaration reveals that Mr. Brown recited words that were not in fact therein. So Mr. Brown's February 2 statement, 2021, says, I knew Miss Paulson was not being honest with me when she denied that she was behind the hacks. Natalie Kennett declaration. I knew she was not being honest with me about her statements that she did not tell anyone to go after me or that she does not tell anyone to do anything, period. Yeah, so Peter is eating her dinner. How do you eat tea? It's an Australian thing for dinner, the evening meal. We call it tea. So what are we thinking about? So how are we thinking about it at the moment? Zing. Frank said zing. There's a couple of zings in there. Frank, yeah, this does need its own bingo card. I would agree. Oh, Frank says, I know it was then I was picking. Amy says that's a very big difference in statement. The great debate, is it tea or dinner? Yeah. Brown's going to need some ice after all those burns, says Aussie girl. Hey, Amy. All right. In addition, defendants' claims of bad faith regarding Miss Barnhart are based almost exclusively on hearsay evidence. Number 9. Defendants cannot submit admissible testimony from Miss Barnhart for the first time in support of their reply. And there's a case there finding the district court should not consider new evidence presented in a reply without giving the non-movement an opportunity to respond. Is that better? All right. So, 1, the unsigned Barnhart declaration. So that's footnote 10, drafted by Mr. Brown. And 2, an incomplete set of emails exchanged between Mr. Brown and Miss Barnhart prior to Miss Barnhart contacting the plaintiff's counsel. So 10 and 11. So 10 says defendants have repeatedly referred to the unsigned, unsworn, and undated declaration of Lorianne Barnhart as the first Barnhart declaration, and the declaration of Lorianne Barnhart filed on the 13th of January 2021 as the second Barnhart declaration. For purposes of clarity and accuracy, plaintiffs refer to the signed January 13th, 2021 declaration of Lorianne Barnhart as the signed Barnhart declaration, and the unsigned, undated declarations drafted by the defendants collectively as the unsigned Barnhart declaration. So number 11 is the declaration of Elena Levine. Oh, wow. All right. Defendants assert that the signed Barnhart declaration, which was signed by Miss Barnhart under the penalty of perjury, is false, while the unsigned Barnhart declaration, a series of 3 documents drafted by defendants' counsel and not signed under the penalty of perjury, is factually correct. Ironically, this completely contradicts Mr. Brown's own email to Miss Barnhart in early January, in which he indicates that the signing of a sworn declaration is generally a solid indication someone is telling the truth. Number 12, supplemental declaration of Michael Brown in support of defendant's motion dismiss. Further, defendant's assertion that Miss Barnhard was eager to sign the unsigned Barnhard Declaration is belied by the fact that Miss Barnhard ultimately chose not to sign it and instead cut off communication with Mr. Brown on January the 11th, 2021. So we got 13 now. We're down to 13 signed Barnhard Declaration. Even more puzzling, the defendant's attack on Miss Barnhard's credibility based on her personal health issues, which Mr. Brown himself was fully aware of as early as December 27, 2020. We're up to 14 in the footnotes. Look, see second supplementary declaration of Brown in motions to dismiss. All right. Yet Mr. Brown had no concerns as recently as 2 days before the signed Barnhard Declaration was filed about using Miss Barnhard to testify favorably for the defendants. 15. See Brown's supplementary declaration. We will be filing an object today. We would like to include a statement from you if you're on board with that. I'd like to stand up for you by filing your declaration if you let me. We're filing something today that addresses the threat Saltz made to you recently. It would be great if you could state you took it as a threat and found intimidated. Plaintiff counsel's conduct was not in bad faith. The filings were not frivolous, and therefore sanctions are not warranted. There's heaps of comments here. I'm not going to get through them all. Aussie Michael Brown is getting some salts in. Yeah, he is in the 230. All right, so we're up to clarification of facts. Facts, people. Mr. Brown has you confused. Is me confused? Yeah. Who is Tarty, says Peter. Very good question. How far he's over said it gets better. Everyone's going to love the footnotes. Correct. What even is a Tarty at this point? Saltzy cites his sources. KJ should take note. Yeah, cool. All right, I think I'm caught up. All right, so here we go. Clarification of facts. Lorianne Barnhard. On December 30, during a meet and confer call to discuss the joint status report and discovery plan, plaintiff's counsel told Mr. Brown that Miss Barnhard had deleted her Twitter account the night before and that Twitter would permanently delete the data from her account within 30 days of the account's deletion. So up to 16. Levine Declaration and Saltz Declaration. The parties agreed to carve out an exception to the discovery stay to allow plaintiffs to subpoena Miss Barnhard's social media account information. Number 17. At no time during the call did Mr. Brown disclose that he'd been in a direct, regular contact with Miss Barnhard for approximately a week. Doo-doo. In fact, in an email to Miss Barnhard later that evening, Mr. Brown indicated that he had deliberately withheld his communications with her. I spoke to Saltz today. They are planning to subpoena your Twitter account because they see that you closed your account and they think there may be evidence there about your connection to Katie. I did not disclose that you and I are in touch. Footnote 19. Brown Declaration. In response, Miss Barnhard wrote, "Figures, what are your thoughts?" Number 20. This email was at 6:18 p.m., was not included with Mr. Brown's declaration. Oopsies. Oopsies. Peter says, well, my computer's not liking all of this. This is about Hardy thinks James may scoot under the radar when he's... Well, that's true. He did underline it to emphasize it. Running late, watching back. Okay, Jessica. All right. So here we go. On January 10, Miss Barnhard sent a direct message to plaintiff's counsel, Michael Saltz. Though Mr. Saltz did not see her message until January 12th, 2021. So we've got his declaration here. Mr. Saltz and co-counsel Elena Levine spoke to Miss Barnhard in a series of phone calls on January 12 and January 13 that lasted approximately 16 hours in total. Number 22 there. During the first call on January 12, Miss Barnhard forwarded certain email chains that were later determined to be only a portion of her correspondence with Mr. Brown. Plaintiff's counsel reviewed the emails while on the phone with Miss Barnhard and realised that the contents revealed a potential attorney-client relationship between Miss Barnhard and Mr. Brown. When asked about Mr. Brown, Miss Barnhard confirmed that she believed that Mr. Brown was acting as her attorney because she repeatedly asked him for legal advice, which he provided. See Levine. Example, Brown, is there anything I can do or should I try to ignore it? I'll have to think about this. For the time being, it's best for you to not make any contact with Katie and vice versa. They're working hard to try to paint you two as a team, and it's not good for either of you. Miss Barnhard, don't worry. I will not say nor do anything without telling you first. You have the right to object to subpoena at a minimum. That would delay everything, and the judge might say you don't have to respond. You have done nothing illegal. I recommend you sit tight, accept service if they come to your door, and we can take it from there. And he offered on multiple occasions to help her respond to the subpoena at no cost. So 26. Do you have the ability to pay for your own lawyer if they issue a subpoena? I can help you with that. You don't need to spend money or hire a lawyer to respond to subpoena. I can give you some assistance with respect to responding to subpoena. I think I can help you with the response for no charge. It's very simple. She also told Mr. Brown that she was going to call plaintiff's counsel directly. Number 28. See Brown's declaration. I will call him tomorrow. Miss Barnhard's explanation that she had terminated any potential attorney-client relationship with Mr. Brown is corroborated by the record. Plaintiffs then proceeded with the interview. 29. So, what do you reckon? Good writing. Debunking says such spirit. The whole outfit's on fire, says Nana Kimber. Mr. Saltzy is a class act, says Gail. Frank says Brown's a naughty man. Kim's got bombs dropping. Brown is really a cowboy, says Laura. Swipe left for anything else. Butterfly, may I ask, is James Charles being sued by Tardy? Sorry, I'm confused with parts. No, I don't believe so, but I could be wrong. Rick says there seems like one professional lawyer that's working on this case. And Frank says when the footnotes take up more space than the filing. I know, and there's lots of details in there. Because Miss Barnhard had closed her Twitter account, Miss Barnhard reinstated the account and provided Mr. Saltz with access. Down to 30, we're up to 30. So we've got a whole pile of declarations. So from 30 to 37 are just where they're going to fall in the declarations. While on the phone with Miss Barnhard, Mr. Saltz reviewed her account and asked her detailed questions about her numerous communications with Miss Paulson. After nearly 11 hours on the phone, Miss Barnhard advised plaintiff's counsel that she just took medication to address her personal health issues. Accordingly, plaintiff's counsel immediately adjourned the interview. On January 13, plaintiff's counsel, Miss Barnhard, resumed their call and after approximately 5 hours completed the interview process. Time was on the essence because Miss Barnhard was eager to correct the mistaken identity of the other Lorianne Barnhard. Miss Levine transmitted the declaration to Miss Barnhard via email on January 13, and Mr. Saltz and Miss Levine then called her again to go over it with her. Mr. Saltz carefully recited the declaration aloud, while Miss Barnhart reviewed the written version to ensure accuracy. After Miss Barnhart had made certain changes to her declaration, Miss Barnhart subsequently signed the declaration without any difficulty, which was filed on January the 13th. So it says 38. Miss Barnhart advised plaintiff's counsel that she used technical difficulties with downloading as an excuse not to sign the unsigned Barnhart declaration. I don't know how to download everything on my phone, so it won't be done. All right. So that's the details as to how they got the information. All right. Gotta love that, to be honest, because Brown has filed so much. There is so much they have. They do have lots of reference. Hi, Elena. Oops. I think it was straight. Yeah, I think I get confused as well. Yeah, it's very confusing. Love how he studied his 11 hours and walked them through how they were taken correctly. Boom. And the blonde card, I don't know how to do that. Not going to happen. One is the unsung hero in this case. Yeah. Brown looks like the fool, says Frank in every right. So here we are at the meet and confer conference. Mr. Brown either was confused during the January 27, 2021 meet and confer with plaintiff's counsel, or he purposely misconstructed what occurred. Plaintiff's counsel never stated that, among other things, that they rushed to complete their interview with Miss Barnhart and get her signature on the signed Barnhart declarations before her medication took effect. So we're up to 40. The record shows that the plaintiff's counsel made every effort to protect Miss Barnhart and preserve her testimony, including pausing the interview after she took her medication and waiting until the following day when Miss Barnhart was clear-headed and alert to continue the interview. So again, 41. In addition, during the meet and confer, Mr. Brown never raised the following substantive issues on which the motion for sanctions is based. A, the Kim Fulmer declaration, including whether any of Ms. Fulmer's testimony was submitted for an improper purpose. B, whether Mr. Salt's direct messages to a friend of Lorianne Barnhart were for oppressive reasons and an improper purpose. C, whether any testimony Mr. Saltz's January 4, 2021 declaration was submitted for an improper purpose. And D, whether plaintiff's counsel violated RPC 4.2 by communicating with Ms. Barnhart. And there's another declaration there. Okay. So now we're going to get up to the argument. Gail says, so Saltzy definitely knows Russia is not China, correct? Hope Saltzy knows he's worth more than his uterus. I hope so too, Laura. That is such a God statement. I want to give out stickers with it on. Laura, I'll definitely get. You'll get in trouble for doing it. Kind of half working. I think my blonde root are showing through. Mr. Brown is making me. All right. So now we're up to the argument. So we've got 10 pages to go before this document, and then we've got to hit the declarations. So argument. Defendants failed to make a meaningful effort to confer with plaintiff's counsel prior to filing the motion. How is your uterus, says Frank. The court's standing order for all civil cases requires that the parties make meaningful effort to confer prior to filing a motion, and motions that do not comply may be summarily denied. 43. See standing order for all civic cases. Here, Mr. Brown failed to make a meaningful effort to confer with the plaintiff's counsel prior to filing an instant motion for sanctions. In fact, defendant's motion for sanctions could have been entirely avoided had the defendant's counsel conducted a meaningful meet and confer with plaintiff's counsel. In addition to explaining their interactions with Miss Barnhard, plaintiff's counsel offered to provide Mr. Brown with correspondence and documents from Miss Barnhard. Mr. Brown not only ignored the offer, but he also cut the meet and confer short. Down here, another declaration. Plaintiff's counsel was deprived the opportunity to address or clarify many, if not all, of the issues identified in the instant motion. So that was the first argument. Oh, well, there's been so many comments. I can't pick them up. All right. So that was that argument. So Rick's going to go to the corner. You get the underlying feeling that Saltz is subtly telling KJ how to investigate on YouTube. Wait, is no one freaking out that there's 26-line paper when everyone freaks out about 40-line versus 46 for Brown? No one's freaking out. It's very interesting because there is something that comes up later that is very funny from Brown. B, plaintiffs moved to strike portions of Mr. Brown's declaration and exhibits attached therein. Pursuant to local civil rule, the Federal Rules of Evidence 801 and 802, the local electronic filing procedures at Section L and 28 USC 1746, plaintiffs object to and move to strike the following evidence submitted by Brown. So they're asking to strike stuff from Brown. Supplemental declaration of Michael P. Brown in support of defendant's motion to dismiss, which contains copies of 3 unsigned declarations of Lorianne Barnhard prepared by Mr. Brown, collectively herein after unsigned Barnhard declaration. Sealed second supplementary declaration of Michael P. Brown in support of defendant's motion to dismiss. That's all that. Declaration of Michael P. Brown in support of defendant's motions for sanctions, including excerpts of Exhibit E that contain verbatim hearsay statements from the unsigned Barnhard declaration. In the absence of a procedural rule or statute, hearsay is inadmissible unless it is defined as non-hearsay under Federal Rule of Evidence 801D or falls within hearsay exception under Rules 803, 804, or 807. And they've quoted case law. The above referenced evidence should be stricken because it consists almost of entirely inadmissible hearsay. The out-of-court statements in these paragraphs are submitted for the truth of the matter asserted and are relied upon by defendants in their motions for sanctions. See motions for sanctions, docket 49. In addition, 28 USC requires that a witness declare under penalty of perjury that the facts contained in the witness declaration are true, and that the witness sign and date the declaration. So we're up to number 49 now. Where are we? 49. So then we've got more case law. Compliance with 28 USC 1746 is mandatory, and declarations that do not comply are inadmissible and cannot support a motion. Whoops. So there we go. More case law. Because the statement failed to meet the requirements of 28, the district court did not abuse. Yeah, they deemed it inadmissible. The unsigned Barnhard declaration and excerpts thereto do not comply with the mandatory requirements of 28 USC and 1746 and are therefore inadmissible and cannot be used to support the motion for sanctions. Because the defendants have filed a motion for sanctions that relies on the inadmissible hearsay on the undersigned declaration that fails to comply with 28 USC and 1746, plaintiffs move for such inadmissible evidence to be stricken from the record. So, strike. Yeah. Okay, so we are getting to the dismiss motion. We could finally get jurisdiction. I think this still has to go on an initial and last name. Shade. Yeah. I need coffee, but I'm too lazy. I think I have a problem. Do you think KJ is kind of fuming big time asking for a friend? I think she might be watching all the videos. So hello, Katie Joy. I hope you are enjoying this. And by the way, today I'm in red. If you'd like to wear something similar tomorrow, that would be good. All right. Plaintiff's counsel's conduct does not warrant sanctions under Section 1927 or the inherent power of the court. 28. Yeah, right. Yeah, that's why she wore a shirt similar to mine. Yeah, hey, Catherine. Why not? Why not? Because I'm in red. Lady in red. No dislike yet? Okay, cool. All right. 28 USC 1927 sets a very high threshold before an attorney will be required to reimburse the opposing party for a portion of its attorney fees, given the likelihood that the fee shifting could chill advocacy. As such, the court must begin its analysis with the presumption that an award of fees is not appropriate and that counsel's conduct falls within the acceptable realm of zealous advocacy untainted by bad faith. Again, more case law. This standard is similar to the standard the Ninth Court applies to requests for fees under the court's inherent authority. More case law. Because of the very potency, the court's inherent powers must be exercised with restraint and discretion. If conduct can be sanctioned adequately under existing rules, the court ordinarily should rely on the rules rather than on the inherent powers to impose sanctions. 54. In this case, there is no basis for an imposition of sanctions against plaintiff's counsel under the high thresholds of 28 USC 1927 or the court's inherent power. Plaintiff's counsel did not advocate frivolously and reckless arguments or unreasonably and vexatiously multiply these proceedings by filing declarations at issue or communicating with Miss Barnhart. So we've got, again, more case law here. What was I up to? 55, wasn't it? Did I just read 55? Yep. I lost my spot. Nor were these declarations filed for an improper use. I don't think she'll be very happy. I get it now. KJ will be read tomorrow. She'll be seeing red tomorrow. Yeah. The Google. If she's watching Soaking All This Brilliant Week by the one that, well, Poppy Seeds is around. I want to make a joke about something. Just say focus all day and watch commentary. Imagine the cartoon. Sass everywhere. Make your own. All right. Joseph, no, really, I'm just reading words. I've got no idea what they mean, though. I've got no idea what the what any of the words mean. I'm just reading them. I think Poppy's trying to take in everything. Starting to sound like KJ's wasted the first 100K of her defense. Yep. But Harrison is the star of the channel. Yeah, I think if I ever sue for defamation, I'll hire Saltzy. Yeah. Plaintiff's counsel did not multiply the proceedings as required by 1927. That's a really cool name for a band, by the way, 1927, but I digress. To be sanctionable under 1927, counsel's conduct must multiply the proceedings in both an unreasonable and vexatious manner. Even where filings are meritless and unnecessary, which is not the case here, sanctions under 1927 are not appropriate if the other party is not required to respond. So again, he's got more. Here, defendants allege that the sanctionable conduct is the filing of 3 declarations in support of the plaintiff's response to defendant's motion to dismiss. However, the 3 declarations, unlike motions, cannot multiply the proceedings, as declarations are not moving papers containing legal argument. Rather, they simply set forth facts which would be admissible in evidence. As these declarations did not require defendants to respond, sanctions under 1927 do not appropriate here. Rick says he's stupid excited about seeing the word vexatious. Yes. He just torched her money. 927. Plaintiff's counsel did not act in bad faith. Defendants failed to provide any evidence showing the plaintiff's counsel acted in subjective bad faith under 1927, which is present only if they knowingly or recklessly raise a frivolous argument or argued a meritless claim for the purpose of harassing an opponent. Under the court's inherent power, which is present only if they acted in bad faith, vexatiously, you got it twice, wantonly, or for oppressive reasons, by delaying or disrupting the litigation, or by hampering enforcement of a court order. Here, none of these 3 declarations at issue in defendant's motion for sanctions were reckless or frivolous filings, nor did the declarations delay or disrupt the litigation. Each of the 3 witnesses proffered testimony that set forth in detail the necessary facts relating to the pending question of personal jurisdiction. There we go, we've got it mentioned, personal jurisdiction. Plaintiff's counsel also thoroughly and carefully interviewed Ms. Barnhart, as well as reviewed the available documentation, including hundreds of interactions on Twitter, to ensure that her proposed testimony was truthful, in good faith, and supported by evidence. Defendants are simply attempting to besmirch plaintiff's counsel and Ms. Barnhart to discredit her testimony, which was provided under the penalty of perjury. A. Ms. Barnhart's testimony was properly obtained and vetted and was filed in response to Ms. Paulson's 2 declarations for proper purpose for providing evidence of defendant's Washington contacts. Defendants speciously assert that due to purported harassment by plaintiff's counsel, Ms. Barnhart finally relented on January 12th and reached out to Mr. Saltz. However, as evidenced by the record, Ms. Barnhart's primary goal in her involvement in this case was to clarify that she was not the other Lori-Ann Barnhart identified in the formal declaration. So again, it's all footnotes here. I contacted you because of the doxing of the wrong Lori-Ann. In her correspondence with Mr. Brown, Ms. Barnhart repeatedly requested that he tell plaintiff's counsel to correct the records so the government employee with Ms. Barnhart's same name would not be at risk of potential harassment. Look what they have done to me and the other Lori. Will anything be put out so this woman's information will stop spreading? Do they know I am not the other Lori yet? I still think they believe I am the other Lori. Do they think I am not the other Lori? And then we've still got more yet. They can show up at Lori's house or work, harass her family now. Can you tell me what is going on with the other Lori? In her case, or of receiving a subpoena meant for Miss Barnhart. Miss Barnhart also told Mr. Brown numerous times that she voluntarily wanted to provide plaintiff's counsel with full access to her social media accounts. 64. Maybe it'd be just easy if I went and met with him myself. I have nothing to hide. For all I care, they can look at my internet activities. I guess I can just call Mr. Saltz and authorize YouTube and Twitter and give it to him all. I will call Mr. Saltz tomorrow. All right. Despite Mr. Brown's assertion that he never represented Miss Barnhart, Mr. Brown repeatedly talked about Miss Barnhart out of contacting Mr. Saltz directly. I understand that impulse, but you need to understand the type of person he is. Can you please talk with me before you do anything? I understand this is very stressful. You should at least speak with me about it. Had Mr. Brown simply followed Miss Barnhart's request to clear up the mix-up with the other Lori-Ann Barnhart as soon as possible, Miss Barnhart would likely have not contacted the plaintiff's counsel. Yet instead of doing as Miss Barnhart asked, Mr. Brown delayed discovery that Miss Barnhart was willing to turn over without court involvement, forcing Miss Barnhart to approach plaintiff's counsel directly. Additionally, plaintiff's counsel spent more than 16 collective hours over the course of 2 days on the telephone with Miss Barnhart, reviewed Mr. Barnhart's extensive Twitter communications with Miss Paulson, and reviewed certain of Miss Barnhart's correspondence with Mr. Brown. Plaintiff's counsel confirmed that the Twitter communications corroborated Miss Barnhart's testimony relating to Miss Paulson. Unsurprisingly, the unsigned Barnhart declaration is based on substantive misrepresentations of fact. For example, the unsigned Barnhart declaration states that the plaintiff's counsel threatened her on Twitter to make a party to her lawsuit, yet no communication exists. Citing Brown, stating he threatened to add you to this lawsuit. Miss Barnhart told plaintiff's counsel that they identified the wrong Miss Barnhart when no such communication exists. And 3, Miss Paulson and Miss Barnhart's communications were limited to a few brief outline conversations unrelated to this matter, when Miss Barnhart's Twitter account reveals hundreds of interactions. 72. Unlike Mr. Brown, plaintiff's counsel spent hours reviewing external documents, including Miss Barnhart's Twitter account, to verify the accuracy of Miss Barnhart's statement in the signed Barnhart declaration. Oh, that was some shade. That was shady. That was shade. Just going to go back and have a look. Where did I get to? I think Saltzy used this 21 days very well, says Frank. If I could do anything, I'd do it for you. Yes, jurisdiction got to mention, Laura. Yay. Assaults. Tell them they cannot throw out. Yeah. Poppy says it's interesting how the same emails can be read in totally polar opposite ways. It is. Yes, again, it's about perspective, isn't it? I'm not the other Laurie. I want it on a t-shirt. Truth and facts always triumph. We got bomb dropping. Poppy says the most favourite thing so far is that some questions to the emails have been answered. That's good. We'll have to have a chat about that later. Well, if Brown did his job then, well, he didn't do anything about Twitter. He didn't know about Twitter, did he? We are on footnote number 70. Yes, we're up to footnote number 70. Saltzy calling out every liar and showing his receipts. Yep. Brown won't need his. Hey, Mama Jama. Yes. The footnote count is already higher than the motion count. Yes, 73 citations, correct. All right. Moreover, Miss Barnhart's declaration is directly related to personal jurisdiction defence raised by the defendants in the motion to dismiss and was filed to refute misstatements by Miss Paulson regarding defendants' contacts in Washington, number 74. The filing of Miss Barnhart's declaration was not in bad faith. The former and Salt's declarations were filed only to address the misrepresentations made in the Paulson declarations as to the nature and scope of the defendants' Washington contacts. Defendants argue that certain references to Miss Barnhart in the declaration of Kim Fulmer are irrelevant and harmful to Miss Barnhart. Yet it is the defendants who repeatedly have publicised these references since Miss Fulmer's declaration was filed, as well as repeatedly publicised Miss Barnhart's personal health issues. Furthermore, Miss Fulmer's inclusion of the reference to Miss Barnhart's previous criminal charge was proper to show that A, Miss Barnhart is a Washington resident and has been for several years. 2, Miss Fulmer reasonably feared for her safety following Miss Barnhart's threats based on Miss Barnhart's history. In addition, the defendant's implication that the charge was dismissed on the merits is not accurate. The charge was dismissed after Miss Barnhart completed a diversion program. Well, there you go. Frank says, I make coffee. I need warning so I don't spit out and fall. All right, I'll try and help. All right. The former declaration also intentionally admitted the affidavit of probable cause in the charging document, which contained the details of the acts charged, including that they involved actual physical harm to a person. Wowzers. Notably, Miss Barnhart, under the penalty of perjury, testified that, except for the statement regarding Miss Barnhart being a government employee, Miss Fulmer's declaration was entirely accurate. Moreover, all of the exhibits to Miss Fulmer's declaration are public records, including the list of public employees, and are readily accessible by a simple internet search. So, says Miss Barnhart also testified that she did not correct other person's statement on Twitter. This Miss Barnhart worked for Washington State Agency. Plaintiff's counsel followed the redaction rules contained in LCR 5.2. There was no private information filed for that. Simple internet search, isn't that somebody's? If you see a message that starts with my name, Frank, that is your warning. KJ will be hard for all that she said. Holy dodgy doo-doo salt spilling it. Yes. Poppy Seed says, I hate to say this, but I think this filing has convinced me Brown is somebody I wouldn't hire, agreeing with his legal arguments aside, few and far between they are. Oh, thank you, Frank. Defendants erroneously accused Mr. Saltz of stating in his January 4 declaration that Miss Barnhart and Miss Paulson engaged in a conspiracy to hide evidence. 81. We're up to 81 now. Mr. Saltz made no such statement in his January 4 declaration. Instead, Mr. Saltz testified that after reviewing hundreds of defendants' vast social media content, he discovered that numerous social media interactions between Miss Barnhart and Miss Paulson were deleted shortly after Miss Fulmer's declaration, which identified a relationship between Miss Barnhart and Miss Paulson for purposes of personal jurisdiction was filed. Mr. Saltz also discovered that after the defendant's motion to dismiss for lack of personal jurisdiction was filed, Miss Paulson told her viewers on a YouTube live stream not to share where they live. Therefore, Mr. Saltz reasonably concluded that evidence relating to personal jurisdiction intentionally was deleted or obfuscated, and as a result was more difficult to find. There is no mention of a conspiracy between Miss Barnhart and Miss Paulson. Evidence was more difficult to find and otherwise comprehend due to the fact there had been a concerted effort to obfuscate and to destroy evidence. So there we go. Guys are like really busy with your talking, which is fine. I don't mind. You can do that. The entire Saltzy thing is a big yeah, nah. Yes, Saltzy said she was. Mr. Saltz's messages with Miss G were not threats. Defendants seek sanctions against plaintiff's counsel based on allegations that Mr. Saltz sent threatening direct messages to Miss Barnhart on January 1, 2021. We're up to 85 now, guys. 85. Notably, the district court in the case cited by defendants did not use its inherent powers to sanction the party's attorney. So they've just sorry to hear that, Michelle. Burning through some money. All right. First, it is undisputed, though purposely vague, in the defendant's motion for sanctions that Mr. Saltz did not send any direct messages to Miss Barnhart, but rather sent direct, non-threatening messages to Miss G. So 86. All right. Second, Miss Barnhart testified that she did not take these messages as a threat. Sorry, as a threat. 87. See signed Barnhart. Plaintiff's counsel's attempts to communicate with me privately to informally obtain information contained no threats. Finally, Mr. Saltbrown's own correspondence reveals that Miss Barnhart did not take Mr. Saltz's messages to Miss G as a threat. On January 11, 2021, Mr. Brown wrote to Miss Barnhart regarding Mr. Saltz's direct messages with Miss G, suggesting it would be great if you could state that you took it as a threat and felt intimidated. 88. Had Miss Barnhart truly felt threatened, there would have been no need for Mr. Brown's suggestion. Rick, that's hard. You're watching this dumpster fire will help warm your heart. It's true. If I was Tidy, I would be too. Maybe Tidy can file just for my information. How many? 124, I believe. I think. Rick says, as a nerd, I'm very much like insults his use of big words. It gives me a small amount of satisfaction to see. Yeah, well, I can't pronounce big words. Miss Barnhart terminated her tiny. Well, I don't agree. I don't agree with that. Honestly, nothing wrong with re-suggesting something you think is true. Okay. Miss Barnhart terminated her attorney-client relationship with Mr. Brown, if any, prior to contacting plaintiff's counsel. Defendants simultaneously assert that Mr. Brown never represented Miss Barnhart and the plaintiff's counsel must be sanctioned because they should have known Mr. Brown represented Miss Barnhart. In defendants' recently filed motion to qualify counsel, defendants argue for 6 pages that Miss Barnhart could never have reasonably assumed that Mr. Brown had represented her. We knew that this was going to come up because this was what we were all saying. On one point, he says he wants to sanction Saltzy for because like she was his client, and then he's argued that no, she wasn't my client. Okay. So, and they've got that defendant's motion to qualify. And acknowledged that Miss Barnhart cut off all communication with Brown, i.e. terminated the attorney-client relationship the day before she spoke with plaintiff's counsel. As such, defendants argue that the instant motion is absurd. How can plaintiff's counsel be sanctioned for violating Mr. Brown's attorney-client relationship with Miss Barnhart if no such relationship actually existed, especially when the defendants acknowledged their communications were cut off before any contact with the plaintiff's counsel occurred? Whether Mr. Brown represented Miss Barnhart and whether any conflicts exist due to that relationship are issues for the courts to determine. What is clear in the evidence, and up to 91, I cut off all communications with defendants and defendants' attorneys. I therefore reached out to plaintiff's counsel by telephone for the first time on January 12, 2021. And in fact, Miss Barnhart did cease communicating with Mr. Brown on January 27. Does instant have specific meaning here or just shade at how quickly he submitted it? I think it's shade. I think it's shade. But I could be wrong. Could be wrong. All right. Yeah. So defendant's request for attorney's fees is not reasonable under the scope of 1927, the court's inherent power. If the court finds the plaintiff's counsel acted in bad faith and award an attorney's fee is appropriate under 28 U.S.C. 1927, the court must first determine how much of the attorney's fees are due to excessive litigation. Then the excess amount is evaluated for reasonableness. The court's purpose in imposing sanctions is to deter certain behaviour and not necessarily to compensate the moving party. Additionally, any attorney's fees awarded under the district court inherent power must be limited to the fees the innocent party incurred solely because of the misconduct. Here set forth above, the declarations filed by the plaintiffs cannot be considered excessive litigation. Even assuming that the declarations were excessive, then any award of sanctions must be limited to the defendant's required response to the declarations, which does not include the instant motion for sanctions. And so here we go. Here's more. All of the... all right. So the total footnotes came to 97. 97. And this comes from the withdrawal of 28. Wait, Brown actually outspent. So, okay, 97 we ended up with. So that is the document. I love these arguments, even if they were OTD. It doesn't matter. Sanctions are not allowed. No. Yeah. Rick says 97, you didn't break 100. I know you would have expected at least 100, right? All right. So 65.1. 65.1 is a declaration. Here we go. This has got some really cool exhibits in it. I like words. I just can't pronounce them. All right, so let's see if I can make this bigger for you. I'm going to make it full screen. Again, I'm going to make it full screen. I'm going to try and bring it across. There you go. You're just going to hear my voice. Declaration of Elena R. Levine in support of plaintiff's opposition to defendant's motion for sanctions. I hope you can read that. Oops. Frank says, when Joe talks at 2 times, it is hysterical. My brain is hearing accent and legal. Thank you, Poppy Seeds. Oh, there's a lot. This one is 58 pages. This document's 58 pages, by the way. There is a declaration from Saltzy, Levine, and Blanco. At this start, I, Elena R. Levine, hereby state as follows. I am attorney admitted pro hac vice to appear before U.S. District Court for the Washington District of Washington in the above captioned matter, and am senior counsel of Jacobson, Russell, Saltz, Nassam, and De La Torre LLP, counsel for the plaintiffs Tatiana Westbrook, James Westbrook, and Haley Bio Products, LLC. In this matter, I am over the age of 18 and am competent to testify to the facts stated wherein. So we've just had Tati and Halo Beauty and James Westbrook all mentioned. 58 pages. I told you, if you need to go get a drink, you need to, yeah. All right. From the very beginning of my interactions with Mr. Brown, he has been unnecessarily confrontational. Because of Mr. Brown's false accusations and misstatements since the outset of this case, it is now official policy in our office that there should be at least 2 attorneys on all calls with potential witnesses and conference calls with the defence counsel in this case. This, unfortunately, has caused plaintiffs additional expense. As in my stated declaration filed on January 27, 2021, in advance of the status conference, Mr. Brown submitted a declaration containing several incorrect and or misleading statements. When, upon close examination, do not match up to the record in this case. These discrepancies have led to an increase in time and expense for the plaintiffs to address. So, No documents have been filed by plaintiff's counsel for an improper purpose. Multiple attorneys have been involved in the drafting and filing of pleadings. So, A, plaintiff's counsel interactions with Ms. Barnhart did not overlap in time with Mr. Brown's communications with Ms. Barnhart. On January 12th, 2021, I did not communicate with Ms. Barnhart in any fashion via telephone or otherwise prior to January 12th, 2021. Miss Barnhart made contact with Mr. Saltz, a partner at my firm. Miss Barnhart is a resident of Washington whose testimony is substantial, established not only the defendant's minimum contacts in the state of Washington through income derived from Washington residents, but also to show a purported agency relationship between defendants and a Washington resident. Plaintiffs did not submit Ms. Barnhart's testimony for an improper purpose, but rather to establish that jurisdiction is appropriate and to refute defendant Paulson's testimony that she has no subscribers in Washington, nor derives any income from the state of Washington. And to refute Ms. Paulson's subsequent testimony that she'd only been in contact over social media with Lorianne Barnhart on a few occasions. Mr. Saltz connected me to the call on January 12th, 2021, so that we could interview Ms. Barnhart together. We spoke to Ms. Barnhart on a series of phone calls on January 12th, 2021. The in total lasted approximately 11 hours. The interview process was so lengthy because we did not rush Ms. Barnhart during our interview, but rather gave her time and respect to tell her story. The length of the interview process also gave us time to investigate and corroborate Ms. Barnhart's statements in real time. So have we got to 5 yet? Yeah. So 4 and 5. So, yep. As stated in Ms. Barnhart's declaration, she was not only a paying member of defendant's YouTube channel for several months, but the two women had communicated hundreds of times for the better part of 2020. During the January 12th, 2021 calls, Ms. Barnhart forwarded numerous emails to both Mr. Saltz and myself containing between Ms. Barnhart and Mr. Brown. I understand now that we did not receive all the emails between Ms. Barnhart and Mr. Brown. I have reviewed the emails contained in docket 43.1, Exhibit B, and there are emails between Ms. Barnhart and Mr. Brown contained therein that I had not previously seen prior to defendant's filing of said document. I understand, based on our telephone conversations on the 12th of January 2021, that Ms. Barnhart's emails had potentially been hacked and or deleted prior to our call. Mr. Saltz and I reviewed and discussed the emails that Ms. Barnhart sent to us, some of which are discussed in Ms. Barnhart's declaration. Additionally, Mr. Brown admitted some communications from his filings. True and correct copies of the missing emails are attached as Exhibit 1. Upon review of said emails, we immediately stopped our interview with Ms. Barnhart and explained that we were concerned that the contents of the emails established that an attorney-client relationship had likely been formed between Ms. Barnhart and Mr. Brown, or at the very least, a prospective attorney-client relationship had been formed. It was at that point that Ms. Barnhart told Mr. Saltz and myself that she thought Mr. Brown was acting as her attorney because she kept asking for legal advice and he kept advising her. Here. So is there anything that we can do? Should we legal advice? Yes, I'd like to see what can be done. Legal advice. So they've outlined it here. Legal advice, you've done nothing legal. Legal advice, legal advice, legal advice, and strategy. All right. He kept saying that he wanted to represent her in responding to the subpoena, and he said he wanted to help her make a record of complaints against Mr. Saltz. Miss Barnhart mentioned to Mr. Brown that she wanted to possibly consult with legal aid. Mr. Brown dissuaded her, telling her that he would represent her at no cost. Both Mr. Saltz and I asked Mr. Barnhart whether Miss Barnhart considered Mr. Brown still to be her attorney. Miss Barnhart indicated that she had terminated her relationship with Mr. Brown. By the way, they're put in, if you look at this footnote, they've listed it all here. I want the court to know what he's doing to harass you. Legal services may help you. Do you have the ability to pay for your own lawyer? Good luck with your case. Terminated her relationship with Mr. Brown and called him a slime ball. Where is it? Where's number 14? Unfortunately, I see who the slime ball is now. So that's who she was referring to Brown as the slime ball, according to this document. Told Mr. Brown she was going to call Mr. Saltz and cut. So up to 15. We're up to 15, by the way. Communications with Mr. Brown. Miss Barnhart told us that she had informed Mr. Brown that she would not be signing any of his draft documents and made an excuse that she didn't know how to download them on her phone, hoping he would take the hint and leave her alone. This situation is akin to someone turning down a suitor with the polite excuse, sorry, I'm washing my hair that night. Sorry, dear, I got a headache. I'm just gonna just show you. I'm a bit behind in the comments. So it's really hard to do all the comments. And hello, Beth. So 2 lawyers required for interaction with Brown. Shade. Yeah. That was funny. That is some pretty big shade there. Christopher Fan always, hello. All right. Professionalism at its best. So just I like how they make the 11-hour sounds and they reveal emails and DMs in that time. Gotta love having multiple lawyers on the case. Yes. I'm looking forward to it. I think I need double the grounds. Yes, I think so. Can Saltzy sanction Brown for the cost? I don't know. Hello, Pearl Girl. Big yikes. They call out the legal advice. They're not wrong. Well, when they list it like that, it does now look like he was her lawyer. Slime ball. Yeah, slime ball. So we've got the slime ball mysteries solved. Yes, Mr. B was the slime ball. Oh, wait on. Let's have a look. The Facebook friend gets that gets solved as well. I think from what I can see here is that Brown underestimated the social media thing. Hard to disagree with. Is that you're saying it's hard to disagree with this? Yeah. Oh, it's incredible. The story of these filings page is so vivid. The dots, yeah, motions for sanctions now onto declarations of support, motions of, yeah. It wasn't apparent in the emails she was pushing off. I don't agree with the comparison at all. Pretty shady, says poppy seeds. Yeah. There's lots of questions. Hello, Beth. Oh, dear. Oops. Who's Mr. X? All right. Hello, Bibbly Bobbly Boo. Right. So I think I've caught up with all the comments. Sorry if without a Michael P. Smile board. Like without a crystal troll. I think is it? Oh, gee whiz! It's just all. There's 130 people. There's 113 people watching, guys. Wow. Michelle says Brown is out of his depth with social media. Saltzy has some experience. Yes, that's true. All right. So I love that. So this situation is akin to someone turning down a suitor with the polite excuse, sorry, I'm washing my hair that night. I love it. I love it. That is shade. Oops. All right. That he would take the hint. So it's like a David and Goliath, but yeah, David and Goliath battle, isn't it? Yeah. All right. Yes, I know. Thank you, Beth. Sorry, I'm washing my edges that night. I would argue there was no hint to taking the emails. I think that is a fair argument, Poppy Seeds, because I would tend to agree to you, but it is a fun shade though. Washing my edges. All right. I must say, yes, I do like it though. The shade is good. I don't know. I'd have to go back and look at the emails, but because she did call him a slime ball though. When we then double checked the emails Miss Barnhart sent us and confirmed what she had told us, and that her communications with Mr. Brown appeared to have been cut off on January 11th, 2021. Miss Barnhart cut off any and all communication with Mr. Brown on January 11th, 2021 concerning any potential representation on this matter before our initial communication with her on January 12th, 2021. This timeline is confirmed in the defendant's motion to qualify counsel to continue to represent defendants, which states at page 4, lines 1-8, even if emails could reasonably be construed as an offer of representation, Ms. Barnhart's own testimony established that she rejected that punitive offer. Indeed, she testified that she was suspicious and not comfortable with Mr. Brown as her attorney, and she therefore cut off all communications with Mr. Brown and proceeded to speak to the plaintiff's counsel the following day. So there you go. Based on our review and conversation with Ms. Barnhart, Mr. Saltz and I were satisfied that the emails that Ms. Barnhart provided us corroborated what she said regarding the termination of any potential attorney-client relationship that existed between Miss Barnhart and Brown. As such, we proceeded with our interview of Miss Barnhart and our review of her documentary evidence. At a certain point in our questioning of Miss Barnhart on January 12th, she informed us that she takes medication for her personal health issues. She later informed us that she had just taken the medicine and that the side effects will eventually make her foggy. Based on this information, Mr. Saltz and I told her we would like to end the interview for the day and pick up again the following day when Miss Barnhart would not be suffering any effects from the medication. I took notes during the phone calls on January 12th, 2021 and drafted Miss Barnhart's declaration based on our telephone conversations and voluminous documents provided with Miss Barnhart. After I drafted Miss Barnhart's declaration, I sent it to Mr. Saltz, who edited the document and added screenshots of evidence provided by Miss Barnhart during the phone call to prove the veracity of Miss Barnhart's statements. On January 13, 2021, Mr. Saltz and I continued and completed the interview process with Miss Barnhart. I subsequently transmitted a draft declaration to Miss Barnhart by email. Mr. Saltz and I then called Miss Barnhart again to go over the draft declaration with her. Because Miss Barnhart had disclosed to us she had personal health issues that caused her to have trouble focusing, Mr. Saltz took his time on the call to verbally recite the entire declaration aloud, while Miss Barnhart physically reviewed it on her end. I followed along with the reading and informed Miss Barnhart that if Mr. Saltz was reading too quickly at any time, she should feel free to interrupt him and ask him to slow down. We proceeded to go over the declaration word for word, line by line, sentence by sentence, to ensure that it was accurate. I did not allow any paragraphs to go by in the declaration without stopping and checking with Miss Barnhart to ask if the wording was accurate and if she had any edits. Miss Barnhart did have some changes to the document which we made. We then resent her the corrected declaration, and Miss Barnhart subsequently executed the declaration and sent it back. I filed the document with the court later that day. Mr. Saltz and I spent 5 to 6 hours on the phone with Miss Barnhart on January 13, 2021. There were some technical issues with Miss Barnhart's Wi-Fi signal that day, so there were multiple telephone conversations on that day. In total, the interview process with Miss Barnhart was approximately 16 hours. From the time of our initial phone call with Miss Barnhart, she emphasized that time was of essence. Specifically, Miss Barnhart had stated that the entire purpose as to why she had reached out to Mr. Brown in the first instance was because she wanted to ensure that the court record was corrected as to identity and that the other woman bearing the same name as her, which Mr. Brown failed to do. So we're up to footnote number 20 now. So there you go. I contacted you because of the docs. It says, where's my computer? Oops, there you go. At no time did Mr. Saltz or I pressure Miss Barnhart to execute her declaration or rush her to sign her declaration. On the contrary, we informed her that she is under no obligation to execute a declaration with our office if she did not want to execute it. We also informed Miss Barnhart that we are not her attorneys and that we only represent the plaintiffs in this case. As with any other witnesses, I told Miss Barnhart that my only request of her was that she be honest as she is signing a document under the penalty of perjury. We also informed her that we cannot advise her on any legal issues and she's free to obtain independent legal counsel at any time, including before signing the declaration. Miss Barnhart indicated that she understood that we were not her attorneys and that she wanted to proceed as it was her paramount desire to clear up the mix-up with the other woman bearing the same name as soon as possible. Once again, Mr. Brown has caused plaintiffs to bear unnecessary additional costs, additional expense in this matter. Had he simply followed Miss Barnhart's stated desire to contact plaintiff's counsel to clear up the mix-up with two identical names as soon as possible, Miss Barnhart would more than likely have not terminated her relationship with the defendant's counsel. Yet, instead of doing so, Mr. Brown used his communications with Miss Barnhart as an opportunity to usurp the subpoena process, thus delaying discovery that Miss Barnhart was willing to voluntarily turn over without court involvement, and to pocket the error made in the Kim Fulmer declaration to use later as a weapon against the plaintiff's counsel as a surprise on a later date. The record filed by Mr. Brown confirms Miss Barnhart had made numerous requests to Mr. Brown to ensure the plaintiff's counsel they needed to correct the record so that the woman bearing Miss Barnhart's same name would not be at risk of potential harassment, and made numerous statements to Mr. Brown of Miss Barnhart's desire to voluntarily provide plaintiff's counsel with full access to his social media accounts. However, After asking Mr. Brown for nearly 3 weeks to make sure that the record was corrected with regard to the other woman bearing her same name, Miss Barnhart became upset that Mr. Brown had not made any contact with the plaintiff's counsel to inform them of the issue, and he still did not know if plaintiff's counsel were aware of the issue. Further, after stating several times to Mr. Brown that she wanted to call Mr. Saltzy and voluntarily provide him with access to all her social media and email accounts because she had nothing to hide and wanted to be done with this, Miss Barnhart became upset that Mr. Brown would talk her out of doing so. To date, plaintiff's counsel has not been contacted by any member of the public agency in question or any other person named Lorianne Barnhart in any other matter. And again, they've listed all, I hope the other Lorianne isn't being harassed. So they've mentioned that here. Maybe it was easy if I just went and met with him myself, have nothing to hide. And then they've listed it all here. Mr. Brown concealed his communications with Miss Barnhart. I just need to have a drink because I've reviewed numerous emails between Mr. Brown and Miss Barnhart dating to as early as December 24, 2020. Mr. Brown was in contact with Miss Barnhart when plaintiff's counsel was seeking court intervention to issue a subpoena for Miss Barnhart's newly deleted social media accounts. Mr. Brown failed to disclose that he intended to represent Miss Barnhart, even for a little limited purpose, let alone that he was in contact with her. My computer has got a mind of its own at the moment. Miss Barnhart's competence and credibility was of no concern to Mr. Brown, as demonstrated by his attempts to procure a declaration from her. It was only after plaintiff's counsel succeeded in obtaining a declaration from Miss Barnhart that Mr. Brown attacked her competency and credibility. Mr. Brown hid his communications with Miss Barnhart from plaintiff's counsel, including myself, stymieing the subpoena process, and offered to object to the subpoena on Miss Barnhart's behalf to delay discovery. Specifically, on December 30, 2020, at 5:37 a.m., Miss Barnhart informed Mr. Brown that her Twitter account is gone. Number 30. Later that day, I engaged in a meet and confer with Mr. Brown, along with Mr. Saltz, Miss Kaplan, regarding Miss Barnhart's missing Twitter account. At no time during the call did Mr. Brown inform us that he was in contact with Miss Barnhart. The admission is confirmed in said email trail when he indicates on December 30 at 5:55 p.m. I spoke with Saltz today. They are planning to subpoena your Twitter account because they see that you closed your account and they think there might be evidence there about your connection to Katie. I did not disclose that you and I are in touch. Saltz even complained to me that you threatened him via DM. So again, there's a whole pile of quotes here from emails. Can you talk to me before you do anything? Mr. Brown also sent Miss Barnhart an email dated January the 8th, 2020, stating you're willing to sign a sworn declaration saying so. That's generally a solid indication that someone is telling the truth. See missing emails, Exhibit 1, attached to Exhibit 1 are portions of an email train between Miss Barnhart and Mr. Brown commencing December 30, 2020, portions which have been admitted from Mr. Brown's compendium of emails between himself and Miss Barnhart. All right. In response, on December 30, 2020, at 6:18 p.m., Miss Barnhart asked for legal advice from Brown and wrote figures. What are your thoughts? So we're down to 32 now. This email at 6:18 p.m. was not included in Mr. Brown's declaration. Based on the aforementioned email, I believe that Mr. Brown did not meet and confer in good faith regarding the parties' joint status report and discovery plan, as Mr. Brown withheld material information from plaintiff's counsel. Additionally, this caused additional expense to plaintiffs as we negotiated the terms of the parties' joint status report and discovery plan, which was filed on January 4, 2020, and I subsequently filed stipulation. In the joint status report and discovery plan, the parties agreed to stay on discovery pending the court's decision on the defendant's motion to dismiss, with a specific exception for plaintiffs to issue subpoenas for Lori-Ann Barnhardt's social media and internet content, as well as her communications with defendants, that they believe may be lost in the absence of such subpoenas. On January 5, 2021, Mr. Brown filed a stipulated order staying discovery pending resolution of defendant's personal jurisdiction challenge, which included this exemption. Mr. Brown also did not meet and confer regarding the stipulated order staying discovery in good faith, as he was withholding material information regarding his communications with the subject of this discovery at issue, Miss Barnhard. So how are you guys all going? So up to page 11 of 58, guys. What do you reckon? Yeah, so I think we've got a couple of the missing emails now. Well, a couple of them, hey. All right. So yeah, so we're at page Saltzy bought all of this. I can't help but notice Saltzy has brought all of this to the importance of jurisdiction. Yes. Motions of sanctions is in the toilet. I think so. Well, my question is, based on some of the stuff that's in here, could it be that, I think someone mentioned it before, could Brown get sanctioned because he seems to have been wasting the court's time? Oh dear. All right. The statements made in Miss Barnhardt's declaration are either undisputed or supported by documented evidence. The statements contained in Miss Barnhardt's declaration are supported by documentary evidence and or are undisputed in defendant's motion. Attached hereto as Exhibit 2 is a table of excerpts from Miss Barnhardt's declaration and supporting evidence. The unsigned draft documents are grossly inaccurate. Well, that's a bit harsh, in my opinion. The labelling of a first and second declaration in defendant's motion is a misnomer. What? Misnomer. Attached to the declaration of Mr. Brown as Exhibit E is a chart of purported differences between the three draft documents transmitted to Miss Barnhard by Mr. Brown, the unsigned Barnhard declaration, and related correspondence juxtaposed against Mr. Brown's impressions of Miss Barnhardt's only sworn declaration. Mr. Brown's comparisons greatly mischaracterize and or misrepresent documents. The following is a non-exhaustive list of examples such as mischaracterizations and or misrepresentations. In one of Exhibit E, Mr. Brown states that nothing in the first draft document is inconsistent with Miss Barnhardt's 1,500-word personal statement. Paragraph 3 of the draft document discusses Miss Barnhardt's prior criminal case and falsely claims that it did not involve harm or threat of harm to any person. Miss Barnhardt's 1,500-word statement makes no mention of her criminal case and does not attempt to deny the public record. Likewise, in paragraph 6 of the draft document states that Miss Barnhard informed Mr. Saltz that he had disclosed the phone number and address of the wrong person. The 1,500-word statement does not say anything about Miss Barnhard sending Mr. Saltz a message containing such detail. Rather, the 1,500-word statement confirms that Miss Barnhard sent Mr. Saltz a more cryptic message that he dots the wrong person. In 2 of Exhibit E, Mr. Brown's statement that Miss Barnhard never objected to anything and was eager to sign a document with his office in its final form is belied on the fact that Miss Barnhard ultimately did not sign the draft document and ultimately cut off communications with Mr. Brown on January 11, 2021. Noting that Mr. Brown states with regard to 3 has any effect on Miss Barnhard's statement that she did not tell Mr. Brown that Mr. Saltz threatened her. In 3 of Exhibit E statement, more threats directed me has the wrong date, is taken out of context and is mischaracterized. This is a response to a direct message after January 1 from a friend of Miss Barnhard's who indicated he tries to make one think he's a friend. Further, the statement was not made to Mr. Brown. Miss Barnhard confirmed during our January 12, 2021 call, after refreshing her recollection and reviewing these direct messages once again, that she was not actually threatened by Mr. Saltz. Additionally, January 1, 2021 is days after Mr. Brown informed Miss Barnhard the subpoena would be issued. Mr. Brown indicated on January 6, 2021 that Mr. Saltz threatened to add Miss Barnhard to a lawsuit. Prior to Mr. Brown's January 6, 2021 email with the false threat, the record is clear that Miss Barnhard had never told Mr. Brown that Mr. Saltz threatened her. Rather, all other references to the word threatened that Mr. Brown claims in his declaration to exist were contained in communications Miss Barnhard wrote after January 6, 2021, and were only then repeated back to Mr. Brown with what he informed her on January 6, 2021. Nowhere in the 15-word statement sent prior to January 6, 2021, did Miss Barnhard state therein that Mr. Saltz threatened her. The email from Miss Barnhard that prompted Mr. Brown's response informed Mr. Brown that Mr. Saltz only stated that Miss Barnhard was being added to the witness list or something. Mr. Brown then mentioned the word threatened to Miss Barnhard for the first time in response to Miss Barnhard by stating, yeah, he threatened to add you to the lawsuit. Mr. Brown also cites to page 146 in docket 52, but there is no such page. Whoopsies. 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 There was no such page. All right. There were no threats made by Mr. Saltz to Miss Barnhard. Subsequently, Mr. Brown sent an email on January 11, 2021 saying, it would be great if you could state that you took it as a threat and found intimidated. So again, examples, Mr. Brown claims that a direct message screenshot of Miss Barnhard's private messages with a friend uses the word threats, is dated January 1 and shows Miss Barnhard's declaration is inconsistent. However, the date of the said message is not January 1, 2021, and said message was not a communication with Mr. Brown, confirming that Miss Barnhard's statements in her declaration remain accurate. Oh, I think so. I think you're going to need it. All right. We're still going. We're at page 14 of 58, people. We might just finish before Emily starts, hey? Just says this is a mess. Yeah. Oh, dear. No, he's got Brown does have some questions to answer, I think. He's been a bit I don't want to use the word tacky. Yeah, I think these are the these first DW declarations aren't, it's mainly exhibits, yeah. Once we get past Elaine's and Saltzy's will be, we're home and hosed. In 4 of Exhibit E, Mr. Brown is asking the court to discount a sworn declaration and instead rely upon an undrafted document prepared by his office. These statements were made at a time in which Miss Barnhart did not have access to her Twitter account to refresh her recollection. Additionally, Mr. Brown did not ask Miss Barnhart to reinstate her Twitter account so he could review it to verify the accuracy of these statements. In contrast, Mr. Saltz did have Miss Barnhart reinstate her Twitter account and spent several hours with Miss Barnhart reviewing several hundred interactions between Miss Barnhart and Miss Paulson. Poppy seeds. I doubt Saltz will try and they may just take the high road and let things, yeah, they may do, because it doesn't look very good. It's fair to say that Brown's going to have egg on his face. Yeah. In reviewing these interactions, Mr. Saltz noticed public tweets when Miss Paulson had asked Miss Barnhart to perform tasks on her behalf. This caused Mr. Saltz to inquire further about Miss Barnhart's interaction with Miss Paulson, which sparked a specific set of memories regarding Miss Paulson asking Miss Barnhart to issue negative reports on the YouTube videos of some of Miss Paulson's competitors. Paulson knew that she lived in 5 of Exhibit E. Mr. Brown states that Miss Barnhart's statement that Miss Paulson knew that she lived in Washington is inconsistent with the statements in his various draft documents. That Miss Barnhart has no reason to believe Miss Paulson knew she lived in Washington. Miss Barnhart's 15-word statement told Mr. Brown, I reached out to her, Miss Paulson, around April and told her my story. In addition, Miss Barnhart informed Mr. Brown that she was Facebook friends with Miss Paulson. This is significant because Mr. Brown had Mr. Brown performed due diligence, he would have learnt that Miss Barnhart's Facebook account displayed her state of residence to be Washington. In 7 of Exhibit E, Mr. Brown matches up 2 consistent statements. Additionally, Mr. Brown did not have the benefit of the Twitter account when drafting the statements. I know Poppy Seeds, all your stuff's going to be sitting in here. So it's like, yeah, tasks and all right. So in 8 of exhibit, so essentially they're just saying he didn't do his due diligence. He needed to check further. So Facebook, Twitter, everything said in here is on the record. Oh dear. In 8 of Exhibit E, Mr. Brown fails to account for the fact that during the interview of Miss Barnhart, Mr. Saltz interviewed her about her 1,500-word statement and asked Miss Barnhart by what method did she share with Miss Paulson her life story. Miss Barnhart then remembered she did it in a lengthy email to Miss Paulson, to which Miss Paulson also replied by email. Oopsies. In 9 of Exhibit E, Miss Barnhart shared her intimate life details in one of the first emails to Mr. Brown, not at the end of their 3-week relationship. During the telephonic conversation, Miss Barnhart stated that she did not trust Mr. Brown because she had expressively told him that it was incredibly important to her that the error in the Kim Former declaration be corrected immediately. She stated she expected Mr. Brown to contact Mr. Saltz at the earliest possible to advise him of the error so that Mr. Saltz would know to file something to the court to correct it. Miss Barnhart then said that her mistrust in Mr. Brown grew over the next 3 weeks, wherein she would continuously prod Mr. Brown as to whether the issue had been addressed. All trust broke down when it became apparent that Mr. Brown was not going to contact the plaintiff's counsel. That is correct, Poppy Seeds. That says so on his website. So here is all that. Again, they've given the dockets and all the statements. In 10 of Exhibit E, Mr. Brown's statements are not inconsistent with the signed declaration. In Mr. Brown's statement that Miss Barnhard was eager to sign a document with his office in its final form, it is belied on the fact that Miss Barnhard ultimately did not sign the document and ultimately cut off communications with Mr. Brown on January 11, 2021. Mr. Brown obviously misread the situation. It's like the old-fashioned breakup, hey? He misread the situation. He thought he was in with a chance, but she was gone. Hello, that amber chick. Oh. All right. All right. So in 11 of Exhibit E, Miss Barnhard's declaration is supported by her statements made to me and Mr. Saltz during a telephonic conversation on the 12th of January, 2021. Mr. Brown's attempt to accuse Miss Barnhard of lying is belied by numerous of documents that prove otherwise. In 12 of Exhibit E, Mr. Brown attempts to change the words of paragraph 28 of Miss Barnhard's declaration and cites to a document that does not say what Mr. Brown says it says. As stated above, Mr. Brown's draft declarations are contradicted by the 1,500-word statement and the cryptic message Miss Barnhard sent to Mr. Saltz. In 13 of Exhibit E, Mr. Brown had evidence that a statement in his draft documents were incorrect. Miss Barnhard only sent Mr. Saltz cryptic messages. So we've got here, or page, as noted at the bottom of the page, as cited by Mr. Brown states, I don't have a printer. Can I use one of those signature apps? It's like a bad breakup. At least if he bombs hard, well, that's true. It does look like a bad breakup. Sorry, I'm not showing everyone's messages. I just can't do both at the same time. So I apologize. Mr. Brown's attempt to procure false testimony from Miss Barnhard. On January 6, 2021, Mr. Brown transmitted 3 versions of a draft declaration to Miss Barnhard for her review, all of which had false statements contained therein and contradicted by written record provided by Miss Barnhard and or the declaration of Kim Fulmer. For instance, paragraphs 2 and 3 of the draft documents transmitted by Mr. Brown to Miss Barnhard contained false statements regarding purported interactions between Mr. Saltz and Miss Barnhard. Specifically, the false statements that the declaration of Miss Fulmer was an effort to follow through on a public threat he directed at me via Twitter in November 2020. And Mr. Saltz responding by public threatening to make me a defendant in the case. There was no such threat. Instead, as stated above, Miss Barnhard told Mr. Brown that Mr. Saltz was soliciting information on Twitter and that Mr. Saltz was going to add Miss Barnhard to a witness list. The only threats were the fake threats invented by Mr. Brown on January 6, 2021 to scare Miss Barnhard into falsely believing that Mr. Saltz was threatening to add Miss Barnhard to this lawsuit. All mentions of threat by Miss Barnhard to Mr. Brown were after Mr. Brown's January 6, 2021 email, and when Miss Barnhard's repeating what she'd learnt from Mr. Brown and not telling Mr. Brown any facts from her own personal experience. Paragraph 3 of the draft document transmitted by Mr. Brown to Miss Barnhard contained false statements regarding the nature of Miss Barnhard's criminal offence, which is a matter of public record and was equally available to Mr. Brown to confirm the contents of said record. The draft documents state that Miss Barnhard's criminal case did not involve harm or a threat of harm to any person. Additionally, Miss Barnhard discussed her criminal matter with Mr. Brown, yet he misstated the nature of the criminal case in the draft documents. So again, you've gone and they've listed in detail exactly what was said. Whew. I do not think Mr. Brown, I do not think Mr. Brown that means what you think it means, Princess Bride. Oh dear. Brown and KJ are two of a kind, says Wind Whispers. Seems like rather than explain the process and meaning of things, Brown wanted to use her feeling of being harassed. It sounds like it. That's for sure. All right. Paragraph 9. We're up to page 18, guys, of 58. Paragraph 9 of the draft documents transmitted by Mr. Brown to Miss Barnhart contains the following false statement unsupported by evidence. I informed Mr. Saltz shortly after the filing of the formal declaration that he had disclosed the phone number and email address of the wrong person. As stated above, nowhere in the record does it indicate that Mr. Barnhart informed Mr. Saltz that he had disclosed the phone number and email address of the wrong person. Paragraph 11 of the draft document transmitted by Mr. Brown to Miss Barnhart contains the following false statement that is contradicted by the substantial written evidence. My interactions with Miss Paulson have been limited to a few brief online conversations unrelated to this matter. The fact that I was a subscriber to her channel for a brief time in 2020, and the fact that last week I sent her a few chats after the filing of the formal declaration. Miss Paulson and I have never been friends and have had little or no direct contact. I have not done anything to coordinate with her to hide evidence or anything unlawful, nor do I have reason to believe she would want me to do so. I have no reason to believe Miss Paulson knew what state I lived in until very recently. First, paragraph 11 of the draft documents are false in regard to the statement that Miss Barnhart does not have a reason to believe Miss Paulson knew that she lived in Washington. As stated above, Miss Barnhart's 1,500-word statement told Mr. Brown, I reached out to Miss Paulson around April and I told her my life story. So again, says one does not generally tell the intimate details of one life story without sharing basic details such as where a person is from. In addition, Miss Barnhart informs Mr. Brown that she was Facebook friends with Miss Paulson. Facebook will get you every time. Hi, Dominus. How are you? This is significant because Mr. Brown performed his due diligence, he would have learned that Miss Barnhart's Facebook account displayed her state of residence to be in Washington. Second, Mr. Brown's attempt to have Miss Barnhart diminish her connection to Miss Paulson is an attempt to create a false narrative. Mr. Brown knew Miss Barnhart had deleted her Twitter account, had not asked her to reinstate it, so he could verify the documented interactions between Miss Barnhart and Miss Paulson. Without actually reviewing Miss Barnhart's Twitter account containing hundreds of interactions between Miss Barnhart and Miss Paulson, Mr. Brown asked Miss Barnhart whether she'd be willing to file a statement that said she'd just not the lorry and that your contact with KJ was limited to a few chats. Mr. Brown did not attest that he actually went over the contents of the draft document word by word, line by line, paragraph by paragraph, as plaintiff's counsel did. Moreover, Miss Barnhart never attested under penalty of perjury as to the contents of the draft document. This is confirmed by the fact she never executed the document. The January 27, 2021 conference call. On or about January 27, 2021, I attended a telephonic conference call requested by Mr. Brown that lasted a total of 40 minutes, not 1 hour as stated in Mr. Brown's time records. The conference call was supposed to be regarding the following 4 anticipated motions to be brought by Mr. Brown. Motions for sanction under Rule 1927, the instant motion for Rule 11 sanctions. So just so you know, we're up to footnote number 70. Will she get to number 100? This is the question. Yeah, Clarissa. Sounds simple, yeah. Take that, Mr. Brown, says Bibbly Bobbly Boo. Okay. Yeah, you reckon it's going to break 150, Rick? Do we take bets? Motion to shorten time on the 21-day safe harbour period for Rule 11 motion. Motion to qualify Mr. Brown to consider to continue to represent defendants. Mr. Brown's entire recantation of said discussions during the meet and confer telephone call is false. During our limited discussion about the instant motion for sanctions, Mr. Brown questioned various aspects of the signed Barnhart Declaration. Mr. Saltz told Mr. Brown during the call that Miss Barnhart takes medication on occasion for her personal health issues. Mr. Saltz explained that the side effect of the medication makes Miss Barnhart foggy. Mr. Saltz then explained to Mr. Brown that Miss Barnhart had advised us that after speaking for approximately 11 hours on January 12, she took her medication. Mr. Saltz told Mr. Brown that this caused us to adjourn our call on January 12th and to pick back up the next day when Miss Barnhart was thinking more clearly. No one told Mr. Brown that Miss Barnhart had told him a false story. Additionally, contrary to his statement in paragraph 5 of his declaration, no one told Mr. Brown that we rushed to complete the interview with Miss Barnhart to obtain a signature. Instead, Mr. Saltz told Mr. Brown that Miss Barnhart sought to correct the public record as quickly as possible because after 3 weeks of communications with Mr. Brown, he had not dealt with the issue. So Mr. Saltz told Mr. Brown that he was more than willing to share the documents that our office reviewed in drafting the declaration. Mr. Brown did not follow up with Mr. Saltz's offer before filing his motion for sanctions. Although we had not finished substantially discussing the issues after approximately 40 minutes, Mr. Brown indicated that his associate needed to depart the call, so the call was cut short. We did not complete the meet and confer process as to the other potential motions that Mr. Brown indicated he wanted to bring. At the conclusion of the call, Mr. Brown did not attempt to reschedule before filing the instant motion. Start spreading your news. Oh, wow. Do I need to take a quick song break now? All right. During the January 27, 2021 call, Mr. Brown asked about the mass flagging referenced in the signed Barnhart Declaration. I informed Mr. Brown that there were videos made about defendant instructing others to flag other YouTube channels in violations of terms of service. Subsequent to the call, I sent Mr. Brown a link of one of these videos, which corroborated Miss Barnhart's testimony on the matter, and Mr. Brown thanked me. However, Mr. Brown pressed forward with his motions for sanctions, ignoring the evidence we had provided to him during the call and insisting that the entire declaration of Miss Barnhart is still false and refusing to meet and confer with us to go over the documents that the plaintiffs had obtained from Miss Barnhart in advance of filing his motion that confirm her truthful and corroborated statements therein. I declare under penalty of perjury, yada, yada, yada. All right, now we get to the exhibits. So we're at page 23, and there are lots of exhibits. Tanya says, didn't KJ claim, yes, he was best lawyer. Yes, she did claim he was the best. He was top at his class. All right, so this is Exhibit 1. So this is to Laurie. So this is one of the missing emails, I believe. It says, I'm waiting to hear back from the lawyer for the other Laurie still. Would you be willing to file a statement that says you're not that Laurie, that your contact with KJ was limited to a few chats? You could explain why you sent those tweets to Kim. It might be good to get your side of the story out there. I can talk anytime. With a reply. I will send the dark draft declaration in the morning. Will you be around to review it? Another email. All right, so this is the missing email. I spoke with Saltz today. They're planning to subpoena your Twitter because they see that you closed your account. I did not so this is what she said. I did not disclose that you are Saltz even complained to me that you threatened him via DM, and she says, figures, what are your thoughts? And this is the SUM account. All right. Can you talk on the phone today? Sure, what time? All right, this is where we get interesting, in my opinion. Right. So this is Twitter. But they do you have any other screenshots of Lori-Ann sending money to KJ in any videos before the loose lawsuit being filed? These ones were not about Saltzy, though. So there's Twitter. Do you have any idea why they are targeting me? I haven't done anything besides defend myself. I was watching a live of Katie today. I could not try and join her channel. The link wasn't working, so I sent her a super chat. My Twitter account is gone. I'm trying to get away from these people. Anytime I do anything, they post it, just for your information. And Twitter, Lori-Ann super chat about you. If people just ask these creators for their sources or correct a lie, we are suddenly plants or socks. 80 socks. Then Twitter. This is Exhibit 2. Now, this is very interesting. This is a table of statements. So what they've done is I'm a Washington resident, undisputed. So they've gone through, I'll make this bigger so you can see it all. They've gone through each of her statements and they've said whether it's undisputed, where it's disputed. So undisputed. They've even put here a screenshot that she was a member. And they've even put a video here. So throughout here, again, they've listed the facts. Now, this is very interesting. I was trying to pull this up earlier to have a good look at it. Because here's a conversation about Kim. So there's quite a few. So again, yeah, undisputed, yeah. I don't know whether I hope you can see that, but look, it's probably Kim and one of her fake accounts, Lori-Ann. Sorry, I'm being pretty quiet, but some of these personal attacks on your mother makes me mad. And the only reason you got I think it came down to the courts should have allowed him to stay in the home. Otherwise, he would have been there was a restraining order at the time. So all of that. So there's quite a few. So again, we're already talking about the fact that there are multiple. There's quite detailed conversations here. See, we've still got more. I know, it's hilarious. Yes, bullying Katie won't make her go away. I don't care what the haters. Oh, she says, I like this. Look at this. You'll see this. It's supposed to be haters, but it says, I honestly don't care what the hatters or anyone else says anymore. They can keep watching and call me crusty. Who cares? It doesn't affect my life anymore. I really want to start recapping before the 90 days. This cast is a damn mess. I would like it if you did. I haven't been watching this season until recently during being on lockdown. I love Ed and Rose and find it funny. And then she goes, Laurie, I adore you. You know that. That doesn't change. So, all right. So let's get this back down again. So I'm not going to go through all of but then there's more of this. Look, there is just so many Twitter messages here. All right. So there's just, so this is really, oops. Just to show you that what they're doing is they're just trying to show the amount of conversations that have happened on Twitter. I mean, this is from the 3rd of the 5th, 2020. Somebody doing great. What have we got here? Here. Sorry, I just saw this. Laurie, yeah, I adore you. That doesn't change. I guess, so then we've got a screenshot here. What's this one? Oh, direct messages between Paulson and Barnhard. So remember, this is there's Nate the lawyer. Remember that page? We all saw that. That has actually never been explained why there was that. So remember, disclosing direct messages between Paulson and Barnhard. Yes, she has been dealing with it for a long time. I don't know how she does it either, but you can tell they're not okay. Pretty sad lives they live. I ignore them because I know my ride or dies will always shut them down. So again, statement, fact. Statement, fact. I saw Sanders Kennedy's videos first. I don't understand why everyone is coming out after you when you didn't release the information. It looks like they were ready to take you down. I'm suspicious. Don't worry, you and Laurie will be on the hunt. So that's Real Housewife. So she was Facebook friends. So they've done that. Screenshot of a request by Paulson to Barnhard to perform a task. Let her know this is why she's blocked, because I know she's trolling. It says compilation video of Miss Paulson issuing instructions to her viewers to mass flag Lil Red's video channel. There's a link. Flagging means reporting violations, so they've even put that there. There's another footnote. I want to make sure. So this is a text. This is a text screenshot. According to this is a text message. I want to make sure I have the correct definition of mass flagging. I think that means she told me to report Cheryl's video. Myself, I have done report it, but I didn't ask anyone else to. Do I have it right? I hope so. I hope I didn't add myself to a lawsuit. No, thank you. I was very worried. So we've got that. So that's about the mass flagging, Cheryl's. Another one, undisputed. Then we've got, so she cancelled her paid membership. Okay, let's have a look. This is supposed to help with this. Oh yes, look at this. This pees me off. Housewife still defends her and never bashes her. A real housewife was one of the most loyal people. She'll be called out for what she did. Housewife has just given her so many chances. Katie stuck up for trolls over Housewife and myself. She forgives trolls, but not real honest people. She'll be. I've been done with her for months now. I don't agree with what the harassers continue to do, but she proves every day why people don't like her. Anyone who gets involved with the KJ situation is at risk of being doxxed or harassed, even making one comment, no matter what side you are on. If you already have issues with mental health or can't help being found out, stay on the sidelines. No story is worth it. Katie is bad. But she isn't a serial killer. Not everyone is strong enough to share their story. It can affect their well-being. I feel like this attention is given to her is actually helping her grow. Just my opinion. My life is so much better since I walked away from her on my own volition. Uni would be better off without Katie. He's lost subs over her and she treats him bad. I no longer support them. Katie cares about Katie. I'm just one sub, so my thoughts don't matter. I just observe and try and keep my opinions to myself. So, and then there's still more here. Yep, so that's Unirock posted a live stream called Live Scope with Katie Without a Crystal Ball. At approximately 56 minutes, Miss Paulson says, Laurie is so mad at me for literally trying to end drama with, I'm sorry I disappointed you, Laurie. I am with Leslie, but I have to do this for myself and I have to move forward. It's just like I can't, I couldn't stay mad at Kyle forever. At approximately 70 minutes into the video, Miss Paulson says, this proves my point. Now Laurie's saying that certain people are looking better every day. So again, they've showed the link. So we've got the screenshot here. 1,000, and then professionals aren't on Twitter. Well, Miss Barnhart is supposed to be a professional herself. She's an employee of Washington, which is a government agency. She conducts herself like a child. Consistent statements that Miss Barnhart did not publicly do anything to correct the information about working for Washington Department. So I reached out to her in April and told her my life story. So this is, again, more examples of screenshots. So disclosing messages. Yep. So they've gone through, as I said, this is another video. Oh, yeah. Hang on. I thought I did all of that. Have I just... So, and then there's a video here about the defendant Paulson's openly admitted in several videos the ability to alter screenshots, and they've listed the videos here. So again, they've gone through the fact that, from the very first interaction I had with Mr. Brown, I found he was being misleading, and then they've gone through the documents or the dockets. So this is confirmed by, so every statement she has made, they have given a receipt or shown proof of in a table. I'm happy to go. I can go back and look at these exhibits another time. Because that later on, because it was pretty, yeah, the Levine, this was probably the hardest. These were the hardest. This was, but yeah, the fact that, you really need to have all the other documents in front of you where she goes, see docket 43, 1 pages 44 of 221. Maybe it would be easy if I went and met with him myself. I have nothing to hide. So they've gone through and they've listed it all. And I keep doing that. That's all right. It's just something that what's in the background is just something I'm working on. All right. So that is the Levine. So I think really the fact that they have documented every statement and shown receipts for every statement or have shown dockets where it's been mentioned, I think is very, very good. The fact that they've shown the evidence of the fact that, there is conversation of, what's this one? There is conversation of, being asked to do stuff. All right. Actually, Saltzy's a 49-page one. So we're getting there. All right. Let me just take another drink. It's 11 o'clock. We've been going for 2 hours. All right. No wonder they took 21 days to respond, eh? Yeah, their cross-referencing and their detail is amazing. They are anyway. Joe, we need a Katie video. As I said, I wanted to show you a Katie video, but I won't have time. I'll have to put it for tomorrow. And we still haven't made it to jurisdiction yet. Okay. So declaration of Michael Saltz in support of plaintiff's opposition to defendant's motions for sanction. Frank, if I showed you the video that I had, there would be things broken. We would be breaking things. All right. I, Michael J. Saltz. So essentially, a lot of this is going to be repetitive from the last one. I'm an attorney, and what? How many what are they called? Things down the bottom did we get to? I think we got to 97. I don't think we got to 100 yet. All right. I'm attorney, so we've got part 1 is the same. Initial interactions with Miss Barnhart. Prior to filing the complaint in this case, I personally had never heard of Laurie Ann Barnhart. However, Catherine says Saltzy is a masterclass artist, this painting picture. However, shortly after filing the said lawsuit, Miss Barnhart took to Twitter on or about November 4, 2020 and accused me of being an imposter and that impersonating an attorney was a crime. I responded by telling her that I was in fact a real attorney and invited her to our offices to come and meet me and our legal team. Miss Barnhart wrote back and said she was of the belief that professionals were not on Twitter and that she certainly would not send information to an attorney over Twitter. I responded to Miss Barnhart that my address, email address, and telephone number were on the pleadings, of which she had tweeted a copy, and that my invitation to come and meet us and help us collect evidence stands. Miss Barnhart then wrote back that I should thank her for sharing my information on my Twitter account is not verified, and I'm followed by random accounts with unusual names. I then thanked her for believing in us. Miss Barnhart then responded that I should get Twitter to verify my account. I then responded to Miss Barnhart that I did not personally know how to get a Twitter account verified, but I would not be opposed to it. I also asked Miss Barnhart if she knew how I could start the verification process. Miss Barnhart said she did not. Below are true and correct screenshots of the initial interaction. There we go. He says you can help collect more evidence throughout the night. Bring food. And then he says, it cites state court rules and we are in federal court, and thank you for believing us. We have been receiving tons of messages and emails giving us information and evidence. If Trump has taught us anything, it is that Twitter is an effective way to reach people. Why does it keep doing that to me? All right. All right. This is where. All right. At no time during this interaction did I threaten Miss Barnhart or tell her that we were going to make her a party to the lawsuit. In fact, it was my understanding Miss Barnhart's Twitter attacks aimed at myself had been diffused, and our Twitter conversation ended in a collegial and courteous manner. I never stated or threatened that I would add Miss Barnhart to the lawsuit. Yeah. You remember seeing that on Twitter, that Amber chick? So the Kim Former declaration. After Twitter interaction with Miss Barnhart, I began to look into Miss Barnhart. I eventually learnt that Miss Barnhart was a longtime supporter of defendant Katie Dree Paulson, Miss Paulson, and that she lived in the state of Washington. I was also informed that Miss Barnhart was purportedly an employee of a state agency. A fact Ms. Barnhart did not publicly deny or express correct despite having the opportunity to do so. Below is a true and correct copy of a redacted screenshot from Twitter, making the then unrebutted claim that Ms. Barnhart, who went by the Twitter handle Bloodtall, was an employee of a state agency. So he's redacted it. This information became relevant after Ms. Paulson filed a motion to dismiss for lack of personal jurisdiction, which was accompanied by a sworn declaration from Ms. Paulson containing the following statements. At paragraph 4 therein, to my knowledge, neither I nor WOACB has any sponsors or subscribers in Washington. To my knowledge, neither NI or WOACB derives any income from the state of Washington. In or about December 2020, I was informed by a former moderator of Ms. Paulson's video chats, Kim Fulmer, that Ms. Barnhart had previously threatened her, purportedly due to a related dispute Ms. Fulmer had with Ms. Paulson. I was informed that Ms. Paulson investigated Ms. Barnhart and had found that Ms. Barnhart was a resident from the state of Washington and had a public Washington criminal record, and that Ms. Barnhart's name appeared publicly available list of state agency employees. Ms. Fulmer's inclusion at the top of the page of the charging documents in her declaration was for the proper purpose of establishing A, that Ms. Barnhart is a Washington resident, has been a Washington resident for several years, and 2, that Ms. Fulmer's stated fear for her safety stemming from Ms. Barnhart's purported threats were reasonable based upon Ms. Barnhart's history. Below is a screenshot I obtained from Ms. Barnhart's Twitter account regarding Ms. Barnhart's stated position on the matter on August 22. I cannot say much because I myself have said a lot of mean things, which I take full responsibility for, but that doesn't make it excusable. I see it all now. I don't know why they did that last night. It certainly isn't going to help the situation. That's right. I think you're right there. Yeah. All right. Further, Ms. Fulmer's declaration intentionally left out details of the actual acts described in the charging documents, including that they involved actual physical harm to a person, and the fact that Ms. Barnhart completed a diversion program to get said charges dismissed. So again, we've got here, we've got footnotes. Mr. Saltzy is a South Scallywag. Yep. Messages from Ms. Barnhart after the former declaration. The day after the former declaration was filed on December 24, 2020, I received unsolicited direct messages to my Twitter account from Ms. Barnhart. Ms. Barnhart never told me that she did not work for a state agency or that Ms. Fulmer incorrectly stated that she did. Ms. Barnhart then sent me another direct message on Twitter on December 25, which was cryptic in nature and taken to me by me as a threat rather than a notice that any information in the former declaration was inaccurate. So we've got here, despite Mr. Brown's attempt to have Ms. Barnhart sign a declaration falsely attesting to contrary facts that her criminal case did not involve harm or threat of harm on any person, or that it was dismissed for lack of merit. The affidavit of probable cause confirms otherwise. Plaintiffs, however, do not wish to attach said public record as an exhibit in these proceedings due to the personal nature of the facts contained herein. However, if necessary, said affidavit will be made available for this court's review upon request. Nevertheless, said affidavit is a public record and was equally available to Mr. Brown to review before he attempted to have Ms. Barnhart sign a declaration falsely, attesting to its contest under the penalty of perjury. All right. In December 25 message, Ms. Barnhart stated that Ms. Fulmer and I dots the wrong person again. You will hear about it next week. However, no further detail was ever provided by Ms. Barnhart with regard to what was meant by the message, and Ms. Barnhart never clarified that she did not work for a state agency. I did not respond to Ms. Barnhart's messages as she instructed me not to. Likewise, prior to receiving said messages, I had made no effort to contact Ms. Barnhart after responding to her efforts to initiate contact with me on Twitter early November 2020. Below and are true and correct screenshots of the relevant portions provided by Ms. Barnhart, with provided screenshots by Ms. Barnhart admitted of said direct messages from Miss Barnhart to myself. So here are they. The screenshots are just a very small amount. I was harassed by about 30 people. I just stood by damn right. I'll stand up for myself and my fault, just like anyone else would. You and Kim Dot's the wrong person again. You'll hear about it next week. Please stop harassing me. I've already asked you to leave me alone. If anyone in my family or is harassed because of you, have doxed me out of malice and nothing more, it will be on you. False accusations aren't cute. I suggest you stop doxing me and accusing me of doing things I haven't done. All those trolls that surround you are harassers. You call yourself a professional, yet you allow your troll army to dox me. Unless you have proof I've done anything even close to illegal, you best stop it. You have already doxed me, and I don't even know who the hell Taddy is, nor have I supported Katie for months because I was harassed and stalked. Miss Barnhart had a private Twitter account. Move. Come back. Oh, it's jumping around. Sorry. Miss Barnhart had a private Twitter account to which I did not have access. I cannot view any tweets she may have made to that account, including any tweets about me allegedly doxing the wrong person. Miss Barnhart expressively informed Mr. Brown several times that she had privated her Twitter account and that only people she followed on Twitter could view her postings on her Twitter page. Prior to January 12th, 2021, Miss Barnhart never informed me, and I did not know that the Laurie Barnhart identified by Miss Former was working at the state agency was not the real Miss Barnhart. My January 4 declaration. After the timely filing of the plaintiff's opposition papers to defendant's motion to dismiss, Miss Paulson posted on social media a false narrative about her connection to Miss Barnhart. One specific tweet purportedly published by Miss Paulson on December 30, 2020 to the public responded to the contents of the plaintiff's opposition papers by stating, "I have no connection to Laurie Ann." Below is a true and correct copy of the screenshot I obtained of said tweet. However, at the time of said tweet, our office was already investigating evidence that had come to light the evening of December 29, 2020, that Miss Barnhart's connection with Miss Paulson was more significant than what Miss Fulmer had attested to in her declaration. So it says, my Twitter is private. Also, my Twitter has been made private, meaning only people I followed on Twitter could see my tweets for at least a month. I'm also blocked on some accounts. So, all right. All right. So this included, but not limited to, the fact that Miss Barnhart had been a behaved member of Miss Paulson's YouTube channels, a fact which otherwise appears directly to negate Miss Paulson's previous statement to this court that she does not derive income from Washington. What is more, on or about December 29, 2020, Miss Barnhart deleted all of her social media accounts, thus effectively obliterating any and all public displays of Miss Barnhart's connection to Miss Paulson and all direct messages on Twitter that Miss Barnhart had with Miss Paulson. It is my personal experience that direct messages on Twitter delete and disappear from my account whenever the account with whom I have communicated deactivates their account. This means the act of deactivating Miss Barnhart's account not only obliterated her Twitter direct message conversation with me, but it would have obliterated her Twitter direct message conversation with Miss Paulson from her Twitter account as well. On December 30, 2020, I participated in a meet and confer with Mr. Brown, Miss Elena Levine, and Miss Susan Kaplan, who was also in attendance. During the call, I explained to Mr. Brown that Miss Barnhart had deleted all of her social media accounts that night before. I also explained to Mr. Brown that we were aware that Miss Paulson had communicated directly with Miss Barnhart on Twitter, and that if we did not get Twitter to preserve all the data from Miss Barnhart's account within 30 days of the account's deletion, all of the data from Miss Barnhart's account becomes permanently unrecoverable. As such, we expressly told Mr. Brown that, to the extent he was requesting the parties stipulate to stay discovery in this matter pending the court's ruling on jurisdiction. We needed to carve out an exception to the discovery stay for Miss Barnhart. Mr. Brown then stated he would agree to carve out an exception to the discovery stay to allow the plaintiff's subpoena to Miss Barnhart's social media account information. At no time during the call did Mr. Brown disclose that he'd been in regular direct contact with Miss Barnhart for approximately a week, or that a person working at the state government agency was not the real Miss Barnhart. Communication with Miss G. On or about January 1, 2020, I received a tweet wherein a person using a Twitter account belonging to someone I will simply identify as Miss G was stating that she had lost contact with Miss Barnhart and was concerned about her. I responded to Miss G privately via direct message on Twitter. Below are true and correct copies of screenshots I obtained from my Twitter account of said conversation I had with Miss G, redacted to protect health information. So there you go. There's the conversation. All right. At no time did I intend to threaten Miss G or Miss Barnhart in these communications. In fact, Miss G confirmed that her perception of the conversation was that I was trying to be a friend. By definition, is not threatening. After Miss Barnhart's signed declaration was filed with this court, and during the time period I'd been granted access to Miss Barnhart's Twitter account to document messages and tweets, I reviewed the direct messages Miss G to Miss Barnhart, in which Miss G stated below that Mr. Brown attempted to get Miss G to sign a declaration accusing me of harassment. Below are true and copy screenshots I obtained from said Twitter. So, watching your declaration on Emily Baker, didn't realize it was out. I feel dumb. So, I'm sorry for being so. I felt betrayed when you said you talked to Saltz. I told Michael that's why my declaration wouldn't have worked. It would have looked like I lied when I said Saltz harassed you and you feared him. I feel the worst is behind you. She used you. She said all of that about Tardy. She's lied, doxed, and manipulated so many. If she has to pay, so be it. She accused me of playing games and deliberately putting off signing the declaration. Nasty B. So cold. Do you understand? I wasn't trying to help Katie. I don't give two F's about her. She wasn't my friend ever. You are my friend. Watching your declaration, I didn't realize it was out. I feel so dumb. So effing glad I did not get involved legally. Footnote number 4, he tries to make one think he's a friend. So a friend of hers, Frank. So it was a conversation between her and a friend that he's titled Miss G. All right. So then it says, her attorney kept wanting more information. I couldn't provide proof. He did say he never wanted. He did say he never wanted another YouTube case. He did say he never wanted another YouTube case. I'm going to go back into hiding so I can take care of myself, get rid of toxic. They tried to get me to do a different declaration. I told them no. And that's love-hearted. Yeah. My brain right now. So whoever Miss G is has messaged Lorianne and said he did say he never wanted another YouTube case. On or about 10th of January 2021 at approximately 7:54 p.m. Another show. I never want another YouTube case. On or about January 10, 2021 at approximately 7:54 p.m., just 2 minutes after Miss Barnhart called Mr. Brown a slime ball in an email to him. I love that. Miss Barnhart sent me a series of direct messages to my Twitter account from an alternate account belonging to her. In these messages, she gave me her phone number, and said that she sees what is happening now and invited me to call her. She said she'd previously called Mr. Brown and said that she got sucked in and believed him too. She said she had no problem giving me access to her social media accounts, that she had nothing to hide. She apologized for previously being rude to me and stated she would answer any questions that we have. Below are true and correct copies of screenshots I obtained from my Twitter account from said messages to me. This is Laurie. You can call me. I have no problem giving you access. I don't have Twitter. My Instagram is just a stock account. I used to watch Instagram live videos, but you can have it. I felt harassed since my post on May 2. I don't recall making any threats, but you can look at the worst stuff. The worst stuff is about me, is everything Real Housewife gave you. I did say if people kept at me, I would have people that would stick up for me. So again, so everyone turned their focus on me and tried to entice me to say or do something. They wanted me to lash out. I could never figure out why everyone wanted to be my friend and why I had so many people wanting to follow me. Well, I've been an idiot this whole time. Then I contacted Katie's lawyer and I got sucked in and believed him too. If it would be easier just to give you full access and not just what I shared with Katie, I can do that. I just don't know how to do it myself. I don't have anything to hide. I'm not hiding documents or anything for Katie. She doesn't have my phone number. I was never in her Discord or a mod for her. The only Discord I was in were the two that Housewife was in. I did have another Discord account before, but I didn't use it. I was invited into one that was run by a man named Heretic, but I never made comments. I looked maybe 1 or 2 times. People were calling CPS, calling police, posting pics of people's houses and saying that they weren't safe. Showing pictures of their guns. I was afraid. I live alone except for my son that I have a part-time, and that made me feel vulnerable. I was tired of being ganged up on and bullied, but it never went beyond that. If I've done anything illegal, I'll certainly take responsibility for that. If me saying that my friends and family will stand up for me, my kids, is a crime, so be it. Any questions, just ask me. Let me know the easiest and the fastest way I can give you access to my accounts. Okay. Yeah, that is interesting, isn't it? Poppy seeds. That's a very interesting speculation. Because I do not accept direct messages on my Twitter account from unknown accounts, the above messages from Miss Barnhard were held in a spam filter, and I did not check until the morning of January 12th, 2021. Once I saw these messages, I texted Miss Barnhard's number on January 12th at 7:38 a.m. to inform her I'd received her messages and to inquire about a convenient time to schedule a call. Miss Barnhard texted me back at 9:38 a.m. on January 12th, 21, so she could immediately talk, and proceeded to call my cell phone. Below is a true, correct screenshot of the said text message. So here's the text message. Hi, Laurie. This is Michael Saltz. This is my cell phone number. I got your message. Let me know when a good time will be for you to talk. I can talk now. My phone seems to be okay now. Stop it, yeah. As soon as Miss Barnhard called me, I joined Miss Levine to the call so I would have an additional witness to help document the conversation. Miss Levine and I spoke with Miss Barnhard for approximately 11 hours on the phone on January 12th, 2021, and approximately 5 to 6 hours on January 13, 2021. During that time, we assisted Miss Barnhard in reinstating her Blood Tool Twitter account, which took a few hours. Although we were able to state that Twitter account, we were unable to recover the direct messages. In addition to reinstating one of Miss Barnhard's Twitter accounts, her other Twitter accounts, which she'd also used to communicate with Miss Paulson, could not be reinstated. Miss Barnhard forwarded a number of emails between herself and Mr. Brown for a review. Miss Barnhard stated that she was uncertain as to whether she had the capability of forwarding to Miss Levine and myself all of her email communications with Mr. Brown, because she'd been the victim of hackers after she'd cut off ties with Mr. Brown, and that they were in her email accounts deleting emails. Below is a true and correct screenshot of the message I received from Miss Barnhard when she stated she believed that hackers were actively in the process of deleting emails as we were speaking. You know, I think that So that I don't think so. I think I'm a bit confused myself with whispers. I'm going to have to let it all settle and fester in my head. Miss Barn had also frequently told us both orally and in writing that we had her full permission to review her social media accounts and emails so we could verify and confirm everything she was telling us. Miss Barnhart also confirmed that Mr. Brown never reviewed or asked to review Miss Barnhart's social media accounts and or email accounts to independently confirm any information that Mr. Brown wanted Miss Barnhart to proclaim on defendant's behalf. Below are true and correct copies of screenshots of some of the texts that I received from Miss Barnhart making said offers. So I don't mind if you inspect my phone records and messages too, so you can verify I haven't spoken to Katie or messaged her. I just want to be believed. To be certain, Miss Barnhart stated to me in a text message that she has a tendency to initially jump to conclusions based on her feeling intimidated by people or stressed. As such, Miss Barnhart apologised for this trait and said she should come with a disclaimer, and said she very much appreciated that Miss Levine and I were taking time to go through her documents and social media history with posts to refresh her recollection of facts and events that had verifiably happened. Below is a true and correct copy of a screenshot of a text message I received from Miss Barnhart. There you go. At the beginning of our conversation, Miss Barnhart, she explained to us that she has certain personal health issues. As such, I knew it was important to treat Miss Barnhart with patience and respect. And therefore, Miss Levine and I remained on the phone with Miss Barnhart for approximately more than 11 hours on the first day, carefully going over documents with her in real time to make sure she understood everything we were asking of her, so that she did not feel overwhelmed or alone in the process. During that call, Miss Levine and I reviewed Miss Barnhart's emails with Mr. Brown and noticed it appeared that an attorney-client relationship, or at least a prospective client relationship, had formed between her and Mr. Brown. Based thereon, Miss Levine and I halted our inquiries until Miss Barnhart could convince us that she had terminated her relationship with Mr. Brown. It just sounds so funny. Terminated the relationship. Have you terminated your relationship? Well, he didn't get the message that I had a headache. Miss Barnhart then confirmed to us she ended her relationship with Mr. Brown and called Mr. Brown a slime ball. It does sound like a breakup. And cut off communications with Mr. Brown. Based on therein, it was our understanding that Miss Barnhart had terminated her relationship with Mr. Brown prior to speaking to us. Oh, no front hugs, Gail. Yeah, that's right, no front hugs. During our conversation with Miss Barnhart, why do I keep doing that? I don't know what I pressed to do that. Oh, I'm not taking. Oh no, I can't take things seriously. During our conversation with Miss Barnhart, I asked her if she would reinstate her Twitter account. Bibbly bobbly boosters, any couples therapy. I asked her if she would reinstate her Twitter account so that we can ensure that the data therein would not be lost. Miss Barnhart did so, which took several hours. Then she gave me her login information so that I could view her Twitter account information. I personally signed into it and went through a significant portion of history of Miss Barnhart's Blood Tall Twitter account. In doing so, I reviewed hundreds of instances with Miss Barnhart and Miss Paulson interacted and communicated publicly with one another. I specifically saw that starting in or around January 2020 to August 2020, Miss Barnhart and Miss Paulson interacted almost every week and sometimes several times a day. Attached here too as Exhibit 1 is a small sampling of screenshots of just some of the interactions between Miss Paulson and Miss Barnhart on Twitter that I obtained from Miss Barnhart's Twitter account with her permission. At one time, Miss Paulson also made a deliberate effort to inform Miss Barnhart that Miss Paulson followed Miss Barnhart on Twitter. There were true and correct copies of screenshots obtained from Miss Barnhart's Twitter account with her permission showing that connection. So she says, I actually follow you, Laurie. I got a front hug today. Oh, was it nice though? Oh yeah, we're nearly there. I'm getting there. We're getting there. All right. On the same day I interviewed Miss Barnhart, I'd been made aware of and watched another video of a YouTube creator that goes by the name of Unirock. He'll be happy he gets mentioned. Specifically on August 14, 2020, Unirock posted on his Periscope a live stream video called Livescope with Kate without a crystal ball, in which he had Miss Paulson on as a guest. Well, as long as they're hunky. At approximately 56 minutes into the video, I witnessed Miss Paulson unilaterally start speaking about Miss Barnhart and state, Laurie's so mad at me for literally trying to end the drama with, I'm sorry I disappointed you, Laurie. I am with Leslie, but I have to do this for myself and I have to move forward. And I can't stay mad at Carl forever. Actually, a good friend of mine. I was friendly with Leslie. I don't know why anyone wants to perpetuate this drama. Later on in the same video, at approximately the 78-minute mark, I witnessed Miss Paulson demonstrate a familiarity with Miss Barnhart, that she was able to identify a person pretending to be Miss Barnhart in the live chat was fake, and stated, there's two Laurie Anns in here. There's someone that's fake. I've uploaded a true and correct copy of the video to the Dropbox for the court's convenience, and there's the link. The only time in Unirock's life he'll ever be mentioned in anything. Oh dear. All right, I then went back to watch the video on the defendant's WICB channel, titled 100K Celebration Stream during the Drum Conversation, which is uploaded to said channel on June 9, 2020, and of which I mentioned in a previous declaration. In watching said video, I personally witnessed at approximately 35 minutes therein, a person I know to be as Miss Paulson display on her video screen a message from Miss Barnhart's YouTube account, along with her picture. I then heard Miss Paulson simultaneously say, oh, this one, Laurie, don't ever get in with Laurie. Laurie remembers your name. Laurie is a catalogue. Laurie didn't like me at one point, and now she's my best friend. A true and correct copy of screenshot I obtained from said video displaying Miss Barnhart's YouTube name and picture, which corresponds to the pictures used. So it says, I know there is so much to learn, headband. Unirock is, he's going to love it. I had downloaded this YouTube video directly from YouTube without the live chat to a Dropbox for the court's convenience. And there's the stream. Said screenshot verifies that Miss Barnhart's YouTube account name had a paid membership loyalty badge next to it and is only available to members of defendants' YouTube channels that pay defendants a recurring monthly fee. Oopsies. Saltz has probably watched more of her videos than anyone else outside the Reddit crew. That'd be funny. Oh, dear. In 15 minutes on the 5th. Oh, wow. Happy birthday. Oh, thank you, Catherine. On January 12th, I discussed these videos with Miss Barnhart. I told her I was confused as to how Miss Paulson could proclaim that she had no connection to Miss Barnhart when she publicly spoke about her familiarity with and intimate knowledge about Miss Barnhart. Miss Barnhart then stated to me that while they were not best friends, as Miss Paulson stated in her June 9, 2020 video, they were significantly closer than an average fan or paid member. Also, during the January 12th, 2020 interview, along with this vein of questioning, I asked Miss Barnhart about the ways by which she would communicate with Miss Paulson. Miss Barnhart told me she would mainly communicate with Miss Poston through Facebook direct messenger, Twitter direct messages, and openly on Twitter. She initially could not remember whether she communicated with Miss Poston via email. I then asked Miss Barnhart about her 1,500-word statement that she wrote for Mr. Brown explaining her story to him. I specifically brought her attention to the portion of the statement that said, I reached out to Miss Poston around April 2020 and I told her my life story. I then asked Miss Barnhart a series of questions based on these statements. First, I asked how is it that she could tell Miss Poston her life story without telling Miss Poston that she lived on or was from Washington. Miss Barnhart stated to me and Miss Levine that she definitely told Miss Poston that she lived in Washington as part of her life story. She also said that she was Facebook friends with Miss Poston and that Miss Barnhart's Facebook page expressively stated immediately next to her name that she lives in Washington. Miss Barnhart said that she'd also informed Mr. Brown that she was friends with Miss Poston on Facebook, which we confirmed in one of her emails with Mr. Brown. I then asked Miss Barnhart by which method did she communicate her life story to Miss Poston. Miss Barnhart stated that she'd sent Miss Poston her life story in an email and that Miss Poston replied to said email. I then pointed out to Miss Barnhart that she'd just admitted to communicating with Miss Poston via email, to which Miss Barnhart responded with, well, I guess we did. Oh, yes, I guess we did. Miss Barnhart then clarified that she rarely communicated with Miss Poston via email, but admitted that it happened. Given the existence of apparent significant connection between Miss Barnhart and Miss Poston, we had documented through Twitter and said videos. I asked Miss Barnhart about Miss Poston's purportedly assigning tasks for her to perform on Miss Poston's behalf. I specifically brought to Miss Barnhart's attention the following screenshots that I have obtained from Twitter. I discussed the below screenshot of Miss Poston telling Miss Barnhart that she knows her ride or dies will always shut Miss Poston's detractors down. I discussed the below screenshot of Miss Poston telling a fan that she considers Miss Barnhart her fiercest and loyalist. You're amazing, Katie. Such a strong person. I want to be like you when I grow up, even though I'm older than you. My fiercest and loyalists next to Blood Tool and a housewife. I discussed the below screenshot of Miss Poston telling Miss Barnhart's friend that she is not worried about her detractors because you and Laurie will be on the hunt. And along with this line of questioning, I asked Miss Barnhart whether Miss Poston had ever asked her to perform tasks on the defendant's behalf. Miss Barnhart initially said she could not recall such an event. Then I pointed out a screenshot I obtained from Twitter of an interaction with Miss Poston asked Miss Barnhart to deliver a message on Miss Poston's behalf. Let her know why this is why she's blocked, because I know she's trolling. After reviewing these messages, Miss Barnhart recalled that Miss Poston had, in fact, asked her to perform certain tasks on defendant's behalf. I then asked Miss Barnhart if Miss Poston had ever asked her to mass flag, or report any videos on YouTube of Miss Poston's detractors. So we've got another footnote. Miss Barnhart was initially reluctant to answer this out of fear of implicating herself and being added to the lawsuit. In response, I assured her that we had no intent of adding her as a party to the lawsuit. Once reassured, Miss Barnhart told us that Miss Poston had asked all of her viewers to mass flag the content of YouTubers. Specifically, Miss Barnhart told us Miss Poston would ask her and others to help mass flag competitors' YouTube channels that made negative comments about defendants in order to have their platforms demonetized or taken away. Miss Barnhart stated that she recalled one such account wherein she was told to flag a video from Lil Red, a YouTube creator and competitor of defendants who was publishing negative content regarding Miss Poston. As a point of confirmation, I subsequently viewed a video on YouTube dated November 8, 2020 titled, Why You Shouldn't Break TOS. This video is documented a collection of multiple instances wherein defendants have publicly asked solicited viewers and followers to mass report, i.e. mass flag other YouTube creators, amongst other people and companies, including the instance identified above by Miss Barnhart. Specifically, at approximately the 33-second mark in said video, I heard Miss Poston say, please report her video. She cannot do this. This is like against terms of service. Then I heard Miss Paulson say again at 1:29, please report her video. All right, well, I'll do it from my computer. The video then shows Miss Paulson purportedly flagging Lil Red's YouTube channel and or content. I have downloaded a true copy of the said video from YouTube and placed it in the Dropbox. In that November 8, 2020 video, I saw the video's live chat a person using the YouTube moniker Canis Dearest. Toady! Which I believe is an account belonging to Miss Paulson's husband, wrote, thanks to everyone who has reported so far. Thereunder, I saw other participants of the video's live chat responds with comments, how do we report it? I just reported her. Not sure I did it right. Reported it. Below is a true copy of the screenshot I obtained from the video, purportedly memorializing said live chat comments in response to Miss Paulson's public request to mass report other YouTube creators. Boop, boop. Oopsies. I'm just going to. So there's Toady. Why are they? There he is. Toady. Thanks everyone who mass reported. How to report it. I just reported her. Just got here. Reported. Agreed. So, oopsies. Someone's in trouble. Toadie's in trouble. Toady got himself he's got himself a mention. I then saw that the video went on to show more of the purported live chat from the video, including the following statements. I thought it was against the rules to ask people to mass report. What am I missing here? What is this stream about tonight? Mass reporting. I also saw in the said live chat other participants stating that the YouTube creator that is the subject of the purported mass flagging request is Lil Red. Below is a true and correct screenshot I obtained from the video's memorialization of said comments purportedly made in reference to live chat. I thought it was against the rules to ask people to mass report. What am I missing here? What is the stream about? Freda is paid too. Lil Red's always streams other content if she can stay awake. The account is called Whiskey Cheetos. I reported her. I told he's now officially, yeah, he's made it. All right. This information therefore provided me the basis of developing the good faith belief that Miss Barnhard was being completely truthful about her being publicly asked by Miss Paulson to mass flag Lil Red's content and or channel. I asked Miss Barnhard if Miss Paulson had ever asked her privately to flag or report a YouTube creator's content or channel. Miss Barnhard responded in the affirmative. Miss Barnhard then described an event when Miss Paulson instructed her in a direct message conversation to flag a YouTube creator and competitor's YouTube channel named Sherelle's World. Miss Barnhard stated it occurred when she brought a video on Sherelle's World YouTube channel to Miss Paulson's attention. Miss Paulson then told Miss Barnhard to report it and instructed her how to do so. Miss Barnhard then stated that she followed Miss Paulson's directions as requested and reported said channel to YouTube for having inappropriate content. Although Miss Barnhard was unable to produce the direct message conversation in which she claimed to have been instructed by Miss Paulson to mass report YouTube channel, the story Miss Barnhard told us was corroborated by information that we've had provided in other instances of Miss Paulson reaching out to others privately to solicit mass reporting of YouTube channels and contents. Specifically, by way of example, but not limitation, I had been provided purported screenshots of a private direct message Miss Paulson had with another individual, wherein Miss Paulson seemingly asked the person, do you have trolls that can mass report? I have been provided no information to make me believe that said screenshots have been fabricated or are not an accurate recordation of the portion of the said direct message conversation. As such, I have developed the good faith belief that Miss Barnhard was being truthful in her depiction. The private instructions Miss Barnhard received to mass flag another YouTube channel that was publishing unfavorable content to Miss Paulson. Below are true and correct screenshots I obtained of said purported private direct messages, conversations that help formulate my good faith belief in the veracity of Miss Barnhard's statements. Well, good riddance to MS Bad Eyebrows. I hope you have a wonderful Thanksgiving with your family today, girlie. Eat lots of food and enjoy the day. Riddance, LRO, riddance. Do you have any trolls that can mass report? No, I don't even know how that would work. Oh well. I'm just a little Canadian gal who supports you. No intent, no genius or anything. Is that a thing, though, like on YouTube? I know people can buy likes and subs. Yep, send the troops into that page. I just sent them. Steve McRae used to co-host on the channel he ran with his partner, Kyle. They split and I'm not connected to them. At a certain point in our questioning of Miss Barnhart on January 12th, 2021, she had informed us she takes medication for her personal health issues. She later informed us that she'd just taken the medication and the side effects would eventually make her thoughts foggy. Based on that information, Miss Levine and I terminated the interview for the day and asked to pick up again the next day after Miss Barnhart was rested and would not be suffering any effects from her medication. As such, Miss Levine and I continued our interview with Miss Barnhart the next day on January 13, 2021. Miss Barnhart sent me a text message on January 13, 2021, making sure that she used the term mass flagging correctly in her edition of events described above regarding her reporting of Sherelle's World YouTube channel, and asked for reassurance that she had not been added herself to the lawsuit by disclosing such information. I assured Miss Barnhart that we had no intent on adding her to the lawsuit. Below is a true and correct copy of the screenshot I took of said text message. I want to make sure I have the correct definition of mass flagging. I think it means she told me to report Sherelle's video. I myself, did report it, but I didn't tell or ask anyone else to. Do I have it right? I hope so. I hope I didn't add myself to a lawsuit. No, thank you very much. I was worried. On 13th of January 2021, Miss Levine and I spent another 5 to 6 hours communicating with Miss Barnhart on the circumstances Miss Barnhart described the circumstances and events that ultimately led to Miss Barnhart tweeting about her toxic relationship with Miss Paulson and that she was better off after having created distance between them. Attached here to as Exhibit 2 are true and correct copies of various screenshots of Miss Barnhart's tweets talking about her separation from Miss Paulson. So, of particular note, Miss Barnhart identified one particular tweet from Miss Paulson after Miss Barnhart had informed her that she would be moving on, to which Miss Paulson wrote to Miss Barnhart, "Laurie, I adore you. You know that doesn't change." We then asked Miss Barnhart if she could explain why Miss Paulson would say such things to Miss Barnhart if there was no connection between the two of them. Miss Barnhart responded that Miss Paulson simply was not telling the truth about the connection or interactions. Below is the screenshot I obtained from Miss Barnhart's Twitter account of said interaction with her permission. Based on Miss Barnhart's answers and supporting documentation throughout the interview, I believe the sections of the proposed declarations that Mr. Brown wanted Miss Barnhart to sign under penalty of perjury contained false information. These include, but are not limited to, now I have to tell you, I think these are just about all the they're actually identical to what was in Miss Levine's, and I'm going to skip through that if that's okay with you guys. And then he's talking about here, ultimately Miss Levine sent Miss Barnhart a draft of his declaration for review. So, and again, this is the same. One generally does not tell intimate details of one's life story without sharing basic details. All right, so then we've got the telephone conference here. It says, Miss Barnhart then downloaded the declaration on her phone without difficulty and returned the declaration signed. That's the only difference. So then that's his standard. So I'm skipping through some parts here just to get through it. I apologize. Mr. Brown's declaration indicates that they told Mr. Brown during the call that Miss Barnhart is easily confused, has poor memory, and suffers from foggy thinking, especially when she's under unusual stress and anxiety and is taking certain medications, as she had been during the prior several weeks since the former declaration was filed. This same sister explained why she told Mr. Brown a fake story over a period of 18 days and 150 exchanged emails. Mr. Brown's entire recantation of said discussions during the telephone call is false. So again, he's gone through and talked about what was said. Rather, I told Mr. Brown that Miss Barnhart was upset with him because her primary concern was to correct the apparent error in the in Miss Fulmer's declaration as soon as possible, and that after nearly 3 weeks, Mr. Brown had taken no steps to inform plaintiff's counsel of said error. So during the 2021 call, Mr. Brown asked about the mass flag in reference to Miss Barnhart's declaration at paragraph 9. Miss Levine informed Mr. Brown that there had been videos about the defendants instructing others to flag other YouTube channels in violation of terms of service referenced above. Subsequent to the call, Miss Levine sent Mr. Brown a link to one of those videos which corroborated Miss Barnhart's testimony on the matter, and Mr. Brown thanked her. However, Mr. Brown pressed forward with his motions for sanctions, ignoring the evidence that we provided to him during the call, insisting that the entire declaration of Miss Barnhart was still false, refusing to meet and confer with us to go over documents that the plaintiffs had obtained from Miss Barnhart in advance of the filing of his motion to confirm her truthful and corroborated statements contained therein. We also did not complete the meet and confer process as to the other potential motions Mr. Brown had indicated that he was intent on bringing at the conclusion of the January 27, 2021 call. Mr. Brown, though needing to cut the call short, did not attempt to reschedule the filing. Hello, everybody that's just joined. 200 people, hey? Wowzers. Wowzers, wowzers. Thank you, everybody. We're nearly at the end of this one, and we're nearly done. I think we're nearly done up after this. I think. All right, Emily D. Baker. She gets a whole section. Mr. Brown incorrectly speculates that I have some sort of pre-existing relationship with YouTube legal commentator and creator Emily D. Baker, and although we are in some manner influencing Miss Baker to produce content unfavorable to Miss Paulson. I have had no pre-existing relationship with Miss Baker, although we both have worked in the LA County District's Attorney's Office. I stopped working there in the late 90s, and it is my understanding Miss Baker started working there mid-2000s. I have never asked Miss Baker to cover any aspect of this case or to say anything about Miss Paulson. Rather, it is my understanding that Miss Baker obtains copies of court documents in this matter and explains them to her audience in a manner that non-legal professionals can understand. The fact that Miss Paulson and or Mr. Brown perceive that the coverage of this case by Miss Baker is unfavorable has only to do with the nature and content of the filings in this case, and not because of any alleged alliance. That's hilarious. Because they've written bad documentation, hey? So again, so now we're up to so here's Exhibit 1. So again, we've got Twitter. Emily made it in. Yeah. Okay, so he's put in lots of... All right, and then so again, here's the Twitter stuff. So we've got the Twitter stuff again. Oh, no, don't tell me my internet's gone. My internet gone? Okay. So again, more Twitter stuff. And Exhibit 2, more tweets. 47 of 49. So again, more Twitter. All right, and then that's that one. So that's Saltzy's one. All right, we've still got another one to go yet. This one's 8 pages. This one's short. And then there's one more document after this. Yes, I know. Thank you, everybody. All right. And after I've read this, I'm going because I've actually got to teach today. I'm teaching kiddies today, so I need to be on my A game. I'm nearly done. And then and then I'll be back later after. Anyway, so this is a declaration of Jeffrey E. Blanco in support of plaintiff's opposition to defendant's motions for sanctions. So Jeffrey Blanco is actually a Washington lawyer. He's the Washington guy. So he's an attorney admitted to appear before the U.S. District Court for the Washington District. Yep. I tell you what, I could probably link them to a Dropbox in the description if you like. I'll do that for you, okay? Frank, I'll put them there for you so you can have a read. Okay, I'm a partner of Carol Biddle and Blanco PPLC and counsel for plaintiffs Tadeo Westbrook, James Westbrook, and Halo Beauty Partners LLC in this matter. So we've got that. All right. I participated in this court's February 2, 2021 status conference. Attached as Exhibit 1 is a true and correct copy of selected portion of the verbatim report of proceedings before the Honorable Barbara J. Rothstein, United States District Court Judge. The other thing, Frank, is if you send me an email, which is on my About page, I can send them to you. I can do that to you as well. That might be easier. On January 25, 2021, Defendant's Counsel Michael Brown sent Plaintiff's Counsel an email to request a meet and confer telephone conference to discuss 4 motions defendants entitled to file. 1, motion for sanctions under Section 1927 and the court's inherent power. Motion 2, motion for Rule 11 sanctions. 3, motion to shorten time on the 21 days safe harbor period for Rule 11 motion. 4, the sanctions motions are premised on your preparation and submission of the Barnhart Declaration, as well as Mr. Saltz's determination in his declaration that Laurie and the defendants conspired to hide evidence. Attached as is Exhibit 2 is a true and correct copy of that email. On January 27, 2021, Michael Saltz, Elena Levine, and I participated in a meet and confer telephone conference with Defendant's Counsel Michael Brown and one of his associates. Mr. Brown failed to mention or address any of the following issues during the meet and confer. The Kim Fulmer Declaration, including whether any of Ms. Fulmer's testimony was submitted for an improper purpose, whether Mr. Saltz's direct message to a friend of Lorianne Barnhart were for oppressive reasons or improper purpose, whether any testimony of Mr. Saltz's January 4, 2021 testimony was submitted for improper purpose, whether plaintiff's counsel violated RPC 4.2 by communicating with Ms. Barnhart. Additionally, plaintiff's counsel never told Mr. Brown during the conference that Ms. Barnhart believed that she was represented by Mr. Brown on January 12, 2021. Plaintiff's counsel received each and every single email between Ms. Barnhart and Mr. Brown. Ms. Barnhart told plaintiff's counsel a story they wanted to hear. Ms. Barnhart told Mr. Brown a fake story, and plaintiff's counsel rushed to complete their interview of Ms. Barnhart and get her signature on the signed Barnhart Declaration before her medication took effect. So he declares under the penalty of perjury. So here's his receipts. So Exhibit 1. So this is a verbatim thing. So it says, quote, I knew Miss Paulson was not being honest with me when she denied she was behind the hack. So Mr. Saltz just told the court that Miss Kennett didn't accuse Miss Paulson of doing this. The declaration in black and white said it did. So they're saying that that wasn't true. This is the meet and confer. This is what they wanted to discuss. And then they're saying, well, they didn't want to discuss it. The very last document is a proposed order denying defendant's motion for sanctions. So this matter comes before the court upon the defendant's motions for sanctions. In ruling this motion, the court considered the pleadings, declarations, exhibits, and briefed filed by parties. Based on the foregoing, it is hereby ordered that defendant's motions of sanctions is denied. They're filled it out. All the judge has to do is sign it. Okay, and that, my friends, is 124 pages of filing documents. I hope you understood them all. Well, actually, I don't really understand a lot of it. But they have gone to really great lengths to try and show that they were very careful with Laurie Ann's statement. Whether she's credible or not, I'm in two minds about that. The decision that has to be made, she was either, if she was okay for Brown, she had to be okay for Saltzy. You can't, say she was not, that she was okay for Brown's declaration, but not for Saltzy. I that doesn't really wash with me. So, that she can be one or the other. And it's a bit like Brown saying, I didn't represent her and then I represented her. So it's just it's just I think it's just a great big mess at the moment. So I don't know. Yeah, so she's going to go through it. Also, look, there's Emily G. Baker. I'm sure Uncivil Law's going to have a look at it. Nate, the lawyer, will probably have a look at it. There'll be lots of lawyers looking at it. They can give you more of a legal perspective as what it stands for as far as the law's concerned. And the statement of the decade. Yeah. But we've read it all. And it's just a mess. So I really don't know what happens from here. I'm assuming that there is a date that's set. That's what he's saying. He's saying that he's not going to pay him. So Nate's on in 2 hours. Okay. Yes, all the lawyers are going to go live now, and I'll be asleep. So that's okay. So I will probably watch them out throughout the weekend. But what I will say is that we'll know how KJ takes it by how she acts. She's either going to churn out a whole pile of videos, or she's going to do a video for money. That's what I think will happen. Anyway, I've got to be up in 5 hours to start my day. Oh, that's okay, Poppy Seeds. So we're gonna we'll have to have a chat about what the new emails that we've seen show and how that fits into the timetable. All right, everybody. So thank you for joining me. It's been a marathon, 3 hours and 18 minutes. Wow. I've still got some coffee left. Guess what? I won't be able to sleep now because I've just had all that coffee. Yeah. She'll probably do a Twitter rant. I think she'll do a Twitter rant. Or someone says she'll be drunk by lunchtime. It'll be very interesting. Well, if she is drunk by lunchtime, it'll give us some entertainment. But I do have an Instagram live to show you from today, which absolutely floored me. I was like on the verge of throwing things. It was that bad. Anyway, we will. You play. Yeah. All right. So I will catch you all later. So I'll see you again soon. Enjoy. Have fun watching all the other lawyers. I shouldn't say all the other lawyers. Have fun watching the lawyers. Have fun watching the lawyers. And I'll catch you later. Yes, I did, Rick. I did see that a whole lot of people had reported her Twitter. Yeah.